Why aren't we showing up there? Yeah, we are. Here we are. Oh, got it. Okay.
Good morning and welcome to the Committee on Professional Responsibility and Conduct. As a reminder, this meeting is being recorded. Under the Bagley-Keene Open Meeting Act, remote members of the committee must be visible on camera unless such appearance would be technologically impracticable. If so, the member shall announce the reasons for their non-appearance during the roll call. Remote members must also disclose any individuals aged 18 years or older in the room with them. Dogs and cats are not included in that. Um, okay, Karen, can you please take the roll?
Yes, Chair. Ali,
Present.
Brown,
Present.
Shivers,
Present.
Joyce,
Present.
Mad Watkins,
Present.
Mercado,
Present.
Migliaccio,
I see, Nick, you're muted.
So sorry, I was muted. Present.
Mohabi,
Present.
O'Reilly,
Here.
Perlman,
Here.
Poindexter absent, Riley.
Present.
Thank you, Chair. We have quorum.
Okay, thank you, Karen. Next on the agenda is the call for public comment. Before we begin public comment, I would like to remind everyone that also under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, COPRAC's work includes drafting advisory opinions on issues of professional ethics based on questions submitted to the committee or developed by the committee on its own initiative, drafting fee arbitration advisories, providing guidance to fee arbitrators administering attorney-client fee disputes, conducting studies and providing advice to the board on professional responsibility, and studying and recommending changes to the rules of professional conduct. The committee sponsors educational and outreach programs. COPRAC does not have authority over attorney discipline matters. Please note that public comment is an opportunity for members of the public to address COPRAC, but during this portion of the meeting, COPRAC members and staff are unable to engage in dialogue or respond directly to the commenters. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Karen.
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and Save Our staff will call on you in the order the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. It is the star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining. First is Audit LA. You have 3 minutes for your public comment.
Yes, good morning. I know I can't report an actual attorney here, but it's a broader scale as to why it's so hard to be able to get help when you're dealing with somebody who I consider a rogue attorney. I think there needs to be, there's not enough written in your rules about that. Okay, I'm talking about Kendrick Moxon. He is a low-level, but a pesky attorney for Scientology. Now, because I am an advocate for victims of Scientology, he has been attacking me, and I mean, like, with defamation, and like he's allowing defamation in their printed materials. I tried to obtain a lawyer to fight it, and I'm told it's probably going to be $50,000 because they put so much money into defense that I would have to pay $50,000 to defend myself with something that is blatantly and easily provable to be defamation and untrue. And I don't know where I can go. I reported it to you guys, and it went nowhere. Okay, then, because I do journalistic, work with it, with following these stories. They're suing. He is suing the city of Los Angeles. All right, he's got like 5 different cases. Even the judge is like asking, why is it 5 separate cases? he's doing that to just harass and annoy, the city, and and it's like, they don't pay taxes, so it's like it's a burden on the taxpayers. That's another element. And yet, and I'm still in the process of reporting that, but like, I don't understand why there's not enough rules with you guys to stop this kind of behavior. Then in the courtroom, okay, I'm a disabled woman, okay, I'm in a chair, and I'm like, I'm 60 years old. Okay, he came out, storming with his roller briefcase and rammed right into me, pulled back and rammed into me again. Didn't even attempt to go around me until the third attempt. It was reported on camera, they see it. But because he says, oh, it was an accident, they're not doing anything about it. So I can be physically attacked, defamed, and and also he authorizes like investigators to my neighbors and all this stuff, and I have nowhere to turn to. I don't know how to get it to where you guys can hear me. You need to do better rules so there's access to people when you have somebody who is absolutely rogue, that they can get help. You guys need to do better. Thank you.
Thank you for your public comment.
Mhm.
Okay. Up next is Mr. Kai. Mr. Kai, you have 3 minutes for your public comment.
Good morning. Sorry. Good morning. My name is Kai Ong from Sacramento. Political power is controlling State Bar of California, Chief Justice and Attorney General, not to investigate Sacramento DA office and SPD make up a story that fake killer Mr. Jung So Fong hit and one kill my father Woon Kong on. DA case number 99F08735. On October 23, 1999 morning, I was searching for my missing father. I drove my car to a scene and a female law enforcement officer showed me my father's wallet and ID. She told me my father's body was removed from the scene and it was a hit and run. 26 years ago, political power already controlled Sacramento law enforcement to make up a fake story of hit and run and a fake killer. Right now, the political power also controlling the government and the justice system to cover up the scandal. It is a serious conduct issue and integrity issue. To consider social responsibility and professional responsibility, State Bar Board of Trustees and all committee members should report this case to California senators, assembly members, and all California citizens to keep an integrity government and justice system. Thank you.
Thank you for your public comment. Up next, we have Burgundy Morgan. You have 3 minutes for your public comment.
Hello, and thank you. This relates to what the State Bar can do in connection with the use of artificial intelligence in connection with the practice of law. I know that there's a lot of discussion about this and some rules are underway, but I wanted to highlight 2 issues. One is the client side use of artificial intelligence. While attorneys have the obligation to keep client information protected and privileged and confidential, it's the client that holds that privilege. And in practice, many clients are uploading everything. And so that's issue number 1, to highlight that so we can prepare for the road ahead. Issue number 2 directly relates to a split that is occurring in courts. For example, there was a federal court judge ruling where a criminal defendant who had uploaded to AI for some self-help, that information was not considered privileged or confidential because it was uploaded to a public use AI. And excuse me, and AIs are not attorneys, obviously. And yet other courts are looking at AI as a tool, like any other research tool. And so given the fact that the courts are splitting, I thought it might be prudent for the State Bar of California to address that issue. And my personal impression is that it really is, a legal tool just like any other. And if you have the safety protocols in place and it's not being trained for public use, that this is a tool just like any other research tool on a computer. But that said, because the courts are split, I thought it would be prudent for the State Bar to get in front of that so that attorneys have clarity and clients have clarity moving forward. I'm complete. Thank you.
Thank you for your public comment. Up next, we have the last phone number digits are 1335. You have 3 minutes to give your public comment.
Hi, can you hear me?
Yes, we can hear you.
Hi, okay. My name is Laura Anderson. I am reporting a very fraud lawyer, Kendrick Moxon. I just heard somebody speaking about him as well. I was a born and raised member, slave, indentured, brainwashed, mind-controlled child, born and raised in the cult of Scientology before it got its religious status. Kendrick Moxon was part of the infiltration of the IRS to get the Scientology status as being a church. As a child being born and raised in this, I was so confused because as Scientologists and as Sea Org indentured servants, we were above the law. We were above religion. We were above everybody. And we thought, that's what we thought. And that's what they think. So Kendrick Moxon, who I was an indentured slave working with as one of his executive seniors above, running crimes, hitting crimes, rape, pedophilia, all kinds of cover-up of crimes that Kendrick Moxon Litchi is covering up and has been doing this for years and years and years. He hides behind a law status and a law license where he is abusing and covering up. And not only that, now that I'm out of Scientology, as I escaped it and fucking got away from these indentured servants themselves who are abusing and making children slave labor work under them and covering up pedophilia and marriages in Vegas. Kendrick Moxon knows about all this. He is the #1 lawyer that handles all this inside of Scientology. Scientology covers up this crime with Kendrick Moxon's law license. He did it in Clearwater when I was 14 years old as an executive over him. He was doing it during the Lisa McPherson case, covering up known evidence of how Lisa McPherson died and the evidence between Scientology and Scientology's, quote, nurses, which are not. They do not believe in mental health care. They literally think that people in wheelchairs are degraded beings. Kendrick Moxon is harassing people that are speaking out, like myself, but also my advocate, also people that are literally children that were trying to get out and couldn't and had to escape and literally lose their family, lose their parents. Kendrick Moxon's own daughter killed herself, and he covered up all the fucking details in Hemet. This man is an insane, walking fraudulent lawyer who keeps enslaving people inside the $1 billion Sea Org contract that he himself has signed. It's not about Scientology. This is about a lawyer who uses the crimes of Scientology to cover it up with his law license. I have major PTSD, cult PTSD from Scientology, specifically Kendrick Moxon, who's continuingly to harass and abuse people mentally in the courtrooms. Again, people who were born and raised calling out this man's crimes, still has a law license after 45 years. It is corrupt. He is fucking corrupt, and he's destroying people's families, including his own, and he's getting away with it in the courts, in the laws. This man has gotten away with so many crimes, and we've written reports to the bar, to the law, to so many people, and he keeps getting away with it by being sneaky. He's a manipulative passive aggressive lawyer who's using his law license to harass individual ex-Scientologists who are speaking out, who are speaking about his abuses and his cover-ups that he is part of constantly. He's in so many lawsuits right now that are completely destroyed with his.
It's been past a minute already. We're gonna have to wrap it up now.
Okay, I want to state his license number so the board has it. That's Kendrick Litchie Moxon, and his bar number is 128240. Kendrick Litchie Moxon, the fraud, corrupt lawyer of Scientology, destroying people's lives currently, right now, that are exposing his crimes in the legal system. He is harassing them.
Thank you for your public comment. Up next is Doug Frithfield. You have 3 minutes for your public comment.
Yes, thank you. I am addressing agenda item 4.10 on the disclosure requirement in Rule 1.7C. I would urge the committee to not throw the baby out with the bathwater and preserve what you can of that disclosure requirement. In my practice, I have found it consistently important to let a client decide whether a lawyer's relationship, professional or business relationship, usually with another client of the lawyer's, is important for client number one to consider and to be fully informed about proceeding with representation in the matter with knowledge that the lawyer represents another client who's a party or witness in the same matter. I disagree with the conclusion of the recommendation where it says that subparagraph B already reaches every relationship or responsibility that threatens the representation, because subparagraph B only addresses those where there is a significant risk of material limitation on the lawyer's duties. And a client, I think, has the right to determine for themselves whether a lesser degree of concern than such significant risk of material limitation might affect their ability or willingness or interest in how to proceed in the representation in that matter. And I would not put much weight in the fact that our state is the only state, apparently, in the union that has this disclosure requirement. There are many things about California's rules that are unique and to be proud of. Thank you very much.
Thank you for your public comment. Chair, there are no more other public comments.
All right, thank you, Karen. Next on the agenda is my approval of the minutes from the last meeting. Not just mine, but our. Are there any corrections or modifications to the open session minutes? If not, hearing none, may I have a motion to approve the minutes? Emil moves, and a second. Allison, thank you. Karen, can you please call the roll?
Yes, Chair. Ali,
Yes, please.
Brown,
Yes.
Joyce,
Yes.
Mad Watkins,
Yes.
Mercado,
Yes.
Migliaccio,
Nick, that's you.
I apologize. I'm going to keep the audio on. Yes.
thank you. Mohebi,
Yes.
Perlman,
Yes.
Poindexter, Riley,
Yes.
O'Reilly.
Yes.
Thank you. The minutes have been adopted.
Okay, thank you. Next on the agenda is my chair's report. I want to start with an idea that we have been using in the sort of leadership of COPRAC to schedule things and just touch on a new concept of putting in a couple of blocks for working group meetings that are always at the same times and days adjacent to the meeting. So they would be like the following week or the second week. One of the things that we've observed is there's a tremendous amount of effort being spent scheduling working group meetings, and everybody's busy, and the working group has 3, 4, 5 people on it. It's a major lift to even set those meetings. So what we would like to do is to set a regular working group block so that if you have a working group, you will also have this meeting. And it might be very short depending on what your working group is doing. But there will be a couple of different ones within it, and you can just pick the one for your working group that you're going to have. It'll be a week or some fixed time after the meeting, and you'll be able to follow up on next steps, which should remove, we hope, this sort of intense effort to try to schedule these meetings. So we'll come up with some more details about this, but everybody should think of working group blocks on Friday mornings, alternating with meeting weeks, obviously, so that a working group can identify when they're going to have their blocks, and to the extent possible, they don't conflict. But ideally, we want to remove the friction around scheduling those working group blocks. So that's underway. I would like everybody on COPRAC to review the internal guidelines and the procedures that we determined were appropriate for governing working groups last year, just to let the staff know within each working group who has the identities that we have identified. And specifically, when we go through working groups today, I think we'll just call them out and ask for people to identify them. If they haven't been identified, we'd like you to do that soon, just so we're working within that process. The goal, of course, is to keep things moving forward and not have everything fall on one person, both because that's too much and because that creates a bottleneck that makes it very difficult for progress to happen. So the other thing that you'll see today is that we're keeping all the items that are out there on the agenda to walk through so that we could have a very quick update and everybody's aware that it's out there and happening. And if nothing's happening, maybe tell us why. That would be a helpful thing. Again, we're trying to keep COPRAC moving forward, not so that everybody has to spend insane amounts of time doing it, but so we can spread the tasks through the working groups internally, and nobody becomes a bottleneck just because of busy schedules or other working things. So these are 3 things that we're working on. As we go through today, we will identify more specifics, and I'll be asking for status updates or who is in these different roles. And we're trying to bring our process much more close to the guidelines that we developed last year. These are obviously our internal guidelines. They can be revised if they aren't working properly, but we think the blocks for meeting times for working groups and identifying these roles will keep us heading in the right direction. Okay. That is the update. The goal continues to be to keep all of the stuff that's on our agenda active and moving forward. And next on the agenda is the staff report from Rachel.
Thank you, Dan. Good morning, everybody. I have a couple of just housekeeping updates. You will notice that item 4.4 on today's agenda, we changed the title of the working draft. It's 24001. It formerly was Ethics of In-House Counsel /IP. The working group renamed that to Lateral Transitions because that really encompasses better what the actual issues are within that opinion and now a potential proposed rule change. So just to let everyone know, we did change that working title. I wanted to let everyone know that item 14.1 on today's agenda regarding pro hoc vice motions is withdrawn. We will not be pursuing it at this time, and so we won't be able to talk about it because it was withdrawn. I did have an update on COPRAC membership. The board met earlier this week and approved all of the submissions for new members, alternates, as well as leadership. So congratulations to Dan, who will soon be moving into the advisor role. Eleanor will be moving into the chair position, and then Carrie will be moving into the vice chair. And happy almost retirement to Raquel and Cassidy. We still have our September meeting, and then we'll switch over to the new leadership and new members at the start of the next co-prac year, which will be our in-person meeting in October. So the new members that we will have joining us, there are 3. The first is Philip Lee. He will be joining immediately to fill a currently open and vacant spot. He is an in-house attorney at Samsung, so we hope that he will be able to join us next month. And then starting in October, we have Dan Bressler, who will be a public member. He runs the Bressler Risk blog, so I know a lot of you are probably familiar with that name. And we also have an attorney member, Lynn Fu. She currently works at Betzetic, but she is transitioning to the ACLU. So we look forward to all of the new members joining us in the fall. I also wanted to thank the working groups who provided early submissions and requests for staff review. It really made things a lot easier for Karen and I as we prepared for today's meeting, so thank you for that. One thing I did want to note, please make sure that you are using the track changes feature in Word. We got some submissions that had manual track changes, and that can make the remediation process difficult for posting things online. So if you could just utilize that Word feature, that would be helpful. And then I know I kind of highlighted a little bit earlier, but we only have 2 Board of Trustees meetings left in this calendar year. We have the September meeting on September 17th and 18th, and then we have the November meeting on November 19th and 20th. So anything that will be voted out to the board today, which I believe is going to be 8.2 and 8.4, those will be going before the board in September. In order to get items before the board for their November meeting, it will need to be voted out next month at our September co-prac meeting. Because of the way that these schedules are, the October 16th meeting, I believe that the board materials are going to be due that following Monday, which leaves staff basically no time to prepare anything for the board. So September really is the kind of last chance to get things before the board this year. If we do have something that's going in October that the committee wants to try and get before the board, I would just need to know several weeks in advance, and it would kind of need to be in final form so that I can start prepping the materials for the board meeting before our October co-prac meeting. So I just want everyone to kind of keep that in mind as they're reviewing the work plan and moving forward in the working groups. That's kind of the timeline that we're working with. We do not currently have anything out for public comment. The rules of professional conduct regarding AI ended yesterday. So Karen will be getting those comments together and sending them out to the working group early next week. And then our next meeting is via Zoom on September 11. I think that's it from me.
Okay, thank you, Rachel. And thank you to the staff for all their hard work on the new membership, because that is a major lift. There were a lot more candidates this year than typically we have seen. Raquel.
You can wait till you're done. If you're not done, are you done? You were talking.
I'm done. Yeah, go ahead.
Okay. I have a question about the working group blocks.
Yes.
Just the rationale for Friday mornings.
Yeah, the rationale is generally that Friday might be a day when people have slightly more availability because we have our meetings on Fridays. And we have alternating leadership follow-ups on Fridays, and part of it is just picking a day that might have a slightly less conflict kind of work-related conflict day. It's not scientific in any way, but it could theoretically be one of 2 days that the working group just picks their block. We want to minimize it being too complex, so there are like 12 different things. And if everybody has to pick different days, then we're right back to the friction that we're trying to avoid. So it might be oversimplified, but the idea was keeping it simple would mean you can set a monthly meeting in your own working group on a different day,
Okay.
but you need to let us know when that is. And the idea would be that if you don't, the default will be Friday.
Okay, all right.
That
I
makes
think
sense.
it's a great idea to have a cadence of this is when the committees meet so that we're not
Right.
running around.
Yeah.
But it seems like, I know in the groups I've been in, there's people that seem to have morning trial, or not trial, but they're in court in the morning. So that was why I was wondering was.
Yeah, I think the rule will be that, and Rachel and Karen can correct and remind me, but I think the rule will be that by default, it will be Friday at this time. And if the working group decides to change to a different day, they should just identify that so we know. The idea, though, is that there is a day preset that everybody shows up and talks and gets the next thing done. Because now, as we've experienced, it's very easy for a month to go by with nothing to happen. Everybody's busy.
Right.
And Rachel, can you remind me what interval we discussed would be appropriate, like following the meeting? I know we decided on one.
Let me check my notes because I don't remember off the top of my head.
Okay.
Thank you.
I think we discussed
Thank you, Raquel.
like the week after the meeting, just so everything was fresh for people having one then.
Yeah, that was it.
Okay, so the default rule will be that basically it would be a block of 10 to 11 or 10 to noon, and everybody will set their working group meetings in the week following our monthly meetings. Unless everybody in the working group decides a different day, and then you'll just report that out. But it should happen in the week following our meetings. And the idea is we talk about something, we say this should happen or that should happen, or if nothing's happening, something should. And then in the following week, the working group gets together and does the thing or does something, right? And we want to keep that happening every month. So we will be then connecting, when we go through the agenda, we'll be probably at the September meeting, identifying for every working group, when is your meeting block, basically. Okay, thank you. Anything else on that idea? Okay. The business of our meeting starts with item 4.1, a discussion of draft 19-0004 and client file release and retention duties. And then 19 in front of the number means it's been around for a long time. And we would like to move it forward. So, Emil.
Yes, thank you so much, Chair. So this has been around for a very long time, and I believe it's gone out for public comment multiple times as well. It most recently came back from public comment after we made some changes based on changes to the law that were essentially effective this year. So we did receive a number of comments, and those comments start on page 35 of the packet for this particular item, like the incorporated comments that staff did. Most of them were in support with either some amendments or generally in support. The working group kind of informally met to discuss these, and we haven't completely come to a consensus, but Eleanor or Bakita or Adam, if you want to chime in, please do. But I think what we came up with generally was that the OCBA's comment about transferring files to a successor counsel totally seems reasonable. We probably don't want to opine on that in this specific opinion. So we might want to just drop in a footnote saying that this opinion does not cover whether transferring your file to a successor counsel satisfies the requirements. CLA also commented on footnote 15 to basically suggest that it might not be relevant. We're okay with that. I think we can remove footnote 15. And CLA also suggested to add the text, I think, on that same page of closed civil. I think it's page 8, which we believe adds clarity and is appropriate. So if everyone agrees with that, I would suggest that we consider sending this out for approval to the board.
Okay, and those are changes that staff has concluded wouldn't be substantive, would be able to be sent to the board without public comment.
I believe so, because I think they're very, very minor, but I'll let staff tell us if they feel otherwise.
Yeah, I agree that I don't believe they're substantive, and they are, I think, just clarifying edits. I don't think it actually changes the substance of the opinion itself. I do, though, staff is going to need an updated copy, a final copy of this opinion in order to prepare it.
So would we still be able to vote on that, or would you like us to submit that and have it on the agenda for next month? Or yeah, next month.
It would probably be easier to submit it for the agenda for next month. That way we can review the updated draft in advance, and then it'll be ready to go at that meeting.
Okay, perfect.
Okay, while we're here on this topic, does anybody have comments about the changes that Emil's described?
No, but can I get some clarification on exactly what we just discussed? I've got a red line copy, which is attached to the agenda. I presume when it's submitted to the Board of Trustees, you're going to take out the red lines and you're just going to make whatever edits were proposed and just approved. So what is it that we're waiting for next month?
So essentially what you're saying is what we're waiting for, which is us to create a clean version. This version that was included in the agenda packet was actually the red line provided by staff to incorporate the comments that were received. And our group did not have a chance to finalize those because we actually met before we received the comments, and then ultimately we were just chatting by email. So we just didn't have a chance to formulate a final version. But I think in substance, we understand which comments and which suggestions that we want to adopt and which ones we don't. So if you have any further discussion, like when you looked at this and you said, hey, your group did not properly consider, or maybe, hey, have you looked at this from this perspective? I think by all means, please let us know and we're happy to discuss.
No, Emil, it's quite the contrary, because I've already taken the time to read this. I agree with the comments made. It appears that other than deleting footnote 15, we're going with the red line as presented. So
no, so just to be clear, so of these red lines and comments, we're proposing to only accept 3 of them. So the first one would be the suggestion to have, to basically, I think it's in comment 1. OCBA made the general comment that the opinion does not address whether you can satisfy these obligations through a transfer to the client or successor counsel. We're responding to that by footnoting that this opinion does not cover that. The next change that we're making would be on page 8, I believe. We would remove footnote 15, and on that same page, the red line, which CLA suggested to add closed civil to that paragraph for clarity. Everything else, I think the consensus was that we would not be making any further edits. But if you have any thoughts or comments, by all means, please tell us.
Nope.
Okay. Perfect.
Okay, so the next one you submit from the working group will be the version with those 3 changes that you have agreed, and these are procedural, don't require more public comment, but everybody will be able to take a look at that and say, yes, we agree with that. We have in the past done approvals, Rachel, I think, where we've just said, these are red line changes. These are the 3 we're making. Staff can make them and send it out. Is there a reason to wait another month? That's Nick's question, I think.
I didn't realize that the working group had met and was ready to move this forward. So, and there was one prior time where we did it, and it took a while to get the final red line version. And our timelines for the September board meeting are just too tight.
Okay. All right, let's then have that working group submit a new one with the 3 that they have approved, and it appears that nobody has comments on those 3 or objections to those changes being the only ones. And we will have this on the agenda to move out next month.
Thank
And
you.
Emil, in the spirit of our internal guidelines, who is your lead drafter, editor, and scheduler in this working group?
I
First
took
of all,
over.
Rachel, those are our 3 roles, correct?
Yes.
Okay.
I took over as lead. We have not assigned. So Vikita, Eleanor, and Adam are also in the group. It looks like we don't have assignments for them.
No time like the present. Who's your editor?
I'm gonna say Eleanor, please.
Okay. And who's your scheduler?
Vikita or Adam, either of you want to?
It's Adam.
Okay. So Adam,
Thanks.
I would ask that you get us scheduled for a finalization of this when you have a moment.
Okay.
Thank you, Adam. Thank you,
Sure.
Emil. Item 4.3, 21-003. Ethics of in-house counsel, business transactions with clients. This was due for a pretty major revision and based on public comments, and Cassidy is going to tell us where that has ended up.
Yeah, so we still need to get together with the working group and talk about revising. So it's not ready for, obviously, for this meeting. But so right now, I think we should just jump to who's on the working group, who's assigned, and let's get the schedule set for the next working group meeting so we can go over what needs to be done. So
Okay.
I think I'm the lead drafter. It's Raquel, Nima, and you, Dan. Right?
Mm-hmm.
I think those are the 3. And I think we may have made assignments before, but I don't remember what they are.
I'm happy to be the editor for this because I've edited before, and I think I'm tracking these changes through.
Okay.
And then we'll just need a scheduler for this group, which will take volunteers.
No.
Like Nima's getting ready to do it. There you
Oh,
go.
Nima. Okay.
Yeah. Yeah, no.
Good.
I don't know.
All right, so
I'm no
Nima.
offense to Nima, but Raquel, you seem to be the very organized person of the whole committee. So.
Yeah.
Okay, so the default for this working group and any other working group, including the previous one, is that there is a working group meeting next Friday at 10 a.m. for all of us to connect. And unless we pick a different time and report that time back, we'll be chatting next Friday at 10 a.m.
Okay, I'm
For-
not
for-
looking at my calendar. It's
yeah.
fine. I'm sure that's fine. And if it's not fine, I will reach out to Nima, who's the scheduler, and we can get it figured out.
Correct. Got that. There you have it.
Can we?
And so the procedure
Yes.
will be that Karen will, having said this now, Karen will then execute the Zoom link process. Is that the final implementation, Dan, of the process? Or
Yeah,
how's-
good question, Raquel. So what would be, Karen, let's say the scheduler comes back and says nothing. The default is yes, the meeting's going to be 10 next Friday. Will you send out Zoom links to each working group? Are they different? How does that work for you? What's the easiest way for that to happen?
I can definitely send out Zoom links, but how do we avoid like overlapping?
Yeah, we've got people at multiple.
They have multiple working groups.
Staff
That's
can
for the
assign-
scheduler to handle.
Yeah, and staff can assign different working groups, different blocks within like that 2-hour window, avoiding overlap of people who are on various working groups.
Okay.
So we can work on that and then send it out to the entire committee and then just let us know if that doesn't work.
Yeah, that's great. Right. We talked about this. The idea would be there would kind of be 10 to noon on the Friday following our meetings. There's 4 half-hour blocks in there. You probably don't need the whole half hour even. But generally, staff will do the first cut to go through and try to create least overlap as possible. If there's overlap and you want to change it, then the scheduler should reach out to Karen to do that affirmatively rather than waiting to be contacted by Karen. And she will then send out Zoom links for your slots. And it'll be just a standing meeting for that working group until it's changed.
Okay. Sounds
So
good.
at the moment, it's 10 a.m., but we'll see what what reduced friction comes from the staff doing that. It's kind of a logic puzzle. If everybody likes those, you can assist. And this was a big revision, so that I know it's taking more time. And it's been around for a little while, but there have been many public comments. It's obviously something that's near and dear to everybody's heart, and people have quite strong opinions about the topic.
Yeah.
Okay. Item 4.4 is 24001. This is the newly renamed Lateral Transitions of in-house counsel and Emil.
Yes, thank you so much. Okay, so this particular opinion has kind of turned into a potential rule change. We recently got some comments from staff that suggested that our proposed rule change may not necessarily be in line with the cases. So I think first off, I'm at a little bit of a loss here in terms of what the best path forward is. Staff did suggest that maybe one approach instead of the proposed rule change, which would essentially align it to what other states are doing, including what New York has done, and maybe more closely align it to the model rules. But an alternative approach would be to instead make a change to a comment. And the other more threshold question is we're looking at disqualification, and then we're looking at the rules of professional conduct. And I feel it's like a chicken and an egg type of thing, because, one cop-out is that the rules of professional conduct are really only enforced by the Supreme Court and ultimately by the bar. The bar says you violated rules of professional conduct. As it relates to disqualification, many courts will look to the rules, but they will still make their own interpretations. So the question is, do we change the rule or change the comment in hopes that it provides clarity to individuals in the discipline context and in terms of how they operate? Or is it better to have the rules reflect what the courts are doing in this other ether, which we consider to be disqualification? And I think the hope is that maybe we can provide a more uniform approach by changing the rule or the comment to help guide what courts may do, but also guide what lawyers should do and what clients should expect. Because I think we should actually look at it not from these 2 buckets, but 3 buckets. Clients and their fiduciary expectations or malpractice issues, the regulatory function of the bar and how lawyers interpret their own conduct and how the bar interprets it. And then on one side, the disqualification and how courts interpret those fiduciary duties that lawyers owe. So happy to address any questions, and sorry to call Carrie out, but Carrie has a lot of context on this specific topic. But maybe before we get in, if anyone has any thoughts about, how we're looking at it and maybe what the approach should be of, whether we're legislating or we're just providing clarity.
Okay, comments on those issues and questions.
And I just want to flag that it would be expected that the case law does not align with our proposed change because it's a change. And courts, I believe, are trying to align themselves with the rules of professional conduct. You'll see that pre-2018, so pre-2018, there was no screening exception. Even if you had billed 30 minutes to a client. If you then went somewhere else and they were adverse to that client in a substantially related matter, your conflict was imputed to the entire firm and the firm was disqualified. That actually happened in a pretty famous case in a Barbie versus Mattel, where an associate had billed 4 hours to Mattel and then went to a firm that was representing MGA, Bratz, and that firm was disqualified because of the 4 hours that an associate had billed on the matter at the prior firm. So that was pre-2018. 2018, the amendment was adopted to allow for screening when the attorney was not a substantial participant. And that language is unique to California. We are the only state that uses the substantial participant test. Substantial participant is defined in comment 1 of Rule 1.10 or 1.10. And it's amorphous. It's lofty. It's open to a lot of interpretation. And to make it even more confusing, when law firms have been post-2018 litigating disqualification motions, they cite all of the jurisprudence pre-2018. So it gets very complicated and has only made the case law even more confusing. And so I think that part of what we were trying to do here was to think about, in big picture, California doesn't like non-competes. California believes in free markets and attorney mobility and employees' abilities to choose where they work and who they work for. And maybe as currently drafted and then in conjunction with kind of very confused case law, whether it's an actual prohibition on attorney mobility or if it's just in effect because it's such a mess and people don't want to take risks when hiring. And we, of course, see this in big law context, but we also see it a lot with in-house counsel because they are sort of steeped in this unique position of confidential information that makes it very difficult for them to move in a small industry. And there's just not a lot of guidance when they are making these decisions. And so that's sort of like the big philosophical elephant that we're trying to eat. And I think we've confused ourselves in the interim.
We provide clarity here. It's one of our functions.
Thank you so much. We've come to the right place.
Yep, you sure have. Does anybody have any insights that would assist? So I'll start by just saying there's nothing in the 2018 rules that suggest what this phrase might mean or why they used it.
Well, there's the comment 1, lists factors to consider. And I apologize, it looks like the proposal actually didn't make it into the agenda packet. Would that be helpful for Karen? Is there any way you can put that up on the screen, please?
We just have to make sure it's posted online, otherwise we can't display it.
Okay. Well, I don't believe it was posted online. So, okay. So.
Yeah. The 1.110 proposal. Yeah. I think it was posted. We're just double checking.
Okay.
Yeah, let's look at it. I think it'd be helpful to see.
Yeah. Oh, yeah, we uploaded it this morning, so it's there now. So we can just
Perfect. Okay.
Carrie, did you want to display it or did you want staff to? You're on mute.
If staff could, that would be great.
Yeah.
I'm a disaster when it comes to sharing.
Give me 1 second.
But for right now, for Dan's question, if we just go to Rule 110's comment 1, that will be the fastest way to answer the pending question.
Right.
So it might be helpful just to scroll down a little bit to the actual text of, it's a red line of what's actually trying to get done. So proposed rule 1.10, and I think there should be, if you just scroll down just a little bit, please, right there. I guess that's not a full red line, right?
I think the comment earlier about not redlining in formats, but in actual was probably directed at me, because I think that this was the one that I had redlined just like for the appearance of a red line. So it might be not great. But the idea behind what we were thinking, and this was in 2025, two states modified their Rule 110. We had Texas and New York. Texas went full ABA and just said a ethical wall and a notice to the former client was sufficient to avoid imputation of conflicts, regardless of the lawyer's prior participation in a matter. New York didn't go quite that far, but New York said they came up with this very kind of common sense. It's also it's an exceptional test. Only New York has it, but they came up with this sort of common sense test that, like, unless they were involved in like the management, direction, and control of a matter, that that a screen and a notice to the other side would be sufficient to resolve imputation of conflicts. And I thought that test, if we're not going to go as far as Texas or many of the other states that have the full ABA, screen notice is sufficient no matter your involvement, if we still wanted to balance client confidence and protection, I thought that the New York test made more sense, because you can imagine like a very junior attorney locked in a basement doing doc reviewing thousands of pages of confidential information for hundreds of hours, and not really thinking that lawyer like has material confidential information, right? Or like would pose a risk at the new firm to some kind of like leakage of that confidential information to the new firm. But under the current test in California, I would be of the opinion that the second-year associate who billed thousands of hours would be disqualified under the current common one test.
Yeah, and just to confirm, I just double checked it. So the red line of 2 Romanet I is correct. The red lines to comment 1 they don't show the deletions, but basically comment 1's like the important part of comment 1 basically says, in determining whether a prohibited lawyer's it says previously, so it's sick, participation was substantial, a number of factors should be considered, such as the lawyer's level of responsibility, the duration of the lawyer's participation, the extent to which the lawyer advised or had personal contact with the former client, and the extent to which the lawyer was exposed to confidential information of the former client likely to be material in the current matter. And that last part of it is really where it appears the courts are focusing in on that rather than the level of responsibility in the prior matter. So, in a very subjective test, they're using one prong, which in Carrie's example would be a low-level doc review person. They were exposed to confidential information versus the level of supervision. And in this case, we're not saying that low-level attorney should be working on that matter. We're asking whether they can be screened in the matter, which seems to be very reasonable. So, we talked about some of the results of the way the rule is currently written and interpreted and how the cases might be interpreted. which is impacting lawyer mobility, not only for big firms, but could be for small firms, could just be for document review where the lawyer was in the document review company that was hired by a law firm, but also, in our particular instance, in our charge, it had to do with the in-house setting as well. Just lateraling between in-house teams is, could be theoretically impossible because that lawyer might have been, apprised of a small level of confidential information, and cannot be screened because screening would not be permitted.
I think it's also worth noting that the working group discussed, the similarity of the work a junior associate might do and that of a paralegal who can cure by screening, and other non-lawyers who have exposure to confidential information working with lawyers, where screening is available to them. And I think it's kind of under the theory that they don't have the strategic responsibility that more senior lawyers have. So it's, yet another area where that's recognized, but we think it should carry over to lawyers as well.
So kind of coming back to Emil's initial framing, it's not unusual for cases in courts to have a different focus than the rules. If you're talking about disqualification, courts can consider other things just that are in addition to or different than strictly whether there was a conflict or not a conflict. So that doesn't bother me as much as just getting the right test.
Yeah, I mean, my view is I think it's pretty clear now, comment or not, that screening does not cure these conflicts. And if we're going to change that, we should change the rule.
Screening does not cure the conflicts with regard specifically to in-house counsel, you're saying?
Yeah, well, any of the conflicts. Yeah.
Okay. Okay.
And I think, sorry to speak for Eleanor, but I think what she's saying is that the status quo right now is that screening would not be available for the folks that the examples that we gave, and therefore we need to make a change.
Okay. Raquel.
I don't think it's adequate to just change the comment to get that point across. I think it's a rule change, and that's how other bars have handled it as well when they want to adopt this position. So I think if we're comfortable with that, it makes a lot more sense to do it in the rule. And it'll be more obvious to people that the change has been made. You do it in the comment, it's guidance on interpretation. I think it just could muddy the water further.
Raquel.
I had not seen this when it was posted this morning. So now that I've seen it and heard the dialogue, can you, Emil, just restate what you stated at the beginning in terms of what the recommendation the working group has? Thanks.
Can we ask the court reporter to? No, I'm kidding. I'm so bad at restating things that I've already said.
Well, I don't know exactly what you said, so I won't hold you to it if you change it. But I realize we're like down deep, and I'm like, what are we? So I thought you said there was maybe the working group wanted to do a rule change, but then staff said something, and so I realized I'm just not clear.
Sure. No, of course.
What are we trying to do?
This would basically be the rule change. The other example that staff suggested was a change to the comments, which we could try to do. And the other option would be potentially to not do anything, right? To basically say, hey, this is not something that we should tackle. And I think the consensus, notwithstanding what staff had suggested to us, is that we would still like to get the rule change going. And so I think what we would do here would be, we would potentially, actually, I'm not sure if we could vote on it today or agendize it again for the next meeting, but basically to, focus on a rule change that would be similar to this, what we have presented, or we could go back to the drawing table and try to do a comment, or we could just say, the committee does not have an appetite to address this issue, and we could drop it.
Okay, thank you. So the specific rule change, based on what I can see on the screen, I can't completely see anything in full. Is it? So what is it? what it,
So this
yeah.
is rule 1.10,
Okay.
which we might call the screening rule. And specifically under A2I, that red line is the exact change. We're just adding words. Then there's the comment 1 to that rule. That red line is not an exact red line. It's basically the addition of words. What the red line is missing is the deletion of certain words, like a number of factors should be considered. It says the primary consideration, but this would be, think of it this way, what you see on your screen is what the new rule would ultimately look like.
Okay, so maybe it's because of the way I have my screen. I'm looking at you all more than this, but okay, so I see 2 on the left-hand side of this 2-column document, correct? And you're talking about the rule change is 2I or
That is
1?
correct.
Okay.
Yeah.
And then if you go straight across to the column, starting with 1 and in determining whether is the comment.
That is correct. So the rule,
loose that, I mean, there's some words, but loosely, that's what you're talking about.
that is correct. And just so you know, so the way the rule starts, 1.10A, it says while lawyers are associated in a firm, and remember, firm is defined to include in-house teams, et cetera, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by the current and former client conflict rules. And then it says unless, and then it starts with 2. The prohibition is based upon a former client conflict rule and arises out of the lawyers association with the prior firm. And then it goes on to say, and the prohibited lawyer did not substantially participate in the management and direction of the same or a substantially related matter, or have substantial decision-making responsibility in the matter on a continuous basis. So in other words, the way that I would, give a 5-second summary of what that part of the rule says is it's not saying substantially participate. It's saying substantially participate in the management and direction or have substantial decision-making responsibility. So it's modifying what substantially participate says by saying it's like a high level of substantial versus a very low level.
So,
Okay.
oh, I have a question. So, but going back to the case law on this, the staff has said that this change is not supported by California law. Is that right?
Somewhat. Maybe, Rachel, could I ask you to address your concerns?
Yeah, sure. So I went and I read, I think it was like a dozen cases in preparation for this. And it looks like the issue in California case law has historically been confidential information. And how much confidential information does this have? Does this attorney have? And so there is a whole long line of case law in California that talks about that. But then it's complicated, like Emil said, because then in, what was it? I think 2018, when Rule 1.110 was finally passed in California, we had some cases that came out after that, some cases that came out before it. So I'm just and I think one of the biggest issues is that in all of these cases, it really is the confidential information that is highlighted. There was a unpublished case that came out like in 2023 that talked about, substantial participation based on the attorney's seniority, the hours billed, exposure to confidential information, even though she didn't have any manager or kind of strategic decision-making role. And the court ended up saying that, she and her in-house team could be screened off. But I think I don't think necessarily, to be quite honestly, the case law is my biggest concern. I think it's the fraught history of Rule 1.110 in California. When I went back and pulled kind of the old board information and old information from the Rules Commission, California attempted to adopt its current version of 1.110 in 2009. And the Rules Commission itself was internally divided about whether or not to put that forward. They did end up putting it forward, and the predecessor to the Board of Trustees, the Board of Governors, declined to adopt it. And so the board ended up shutting that down in March of 2010. And the board was specifically concerned with the fact that the case law was unsettled in California in terms of part of it, but they also said at the same time that imputation was already settled in case law, so it didn't need a rule. So then fast forward to 2018, and the Rules Commission again reconvened and put forth two different proposals for 1.110. One of them was the version that California currently has, and that was ultimately adopted. The other was more the model rule version, which allows for more expansive screening. And at that time, when presented with both options, California specifically chose the more restrictive screening option, and that ended up passing. So just given how difficult it was to get to 1.110 as it currently exists, my concern is I don't want COPRAC to spend all of this time working on something that I'm not sure if we're going to be able to push forward and make it through the board and the Supreme Court. I have no idea what the board's, opinion on this is, or what the Supreme Court's opinion on this is. But when I write up the staff memo, there is a section that talks about history of this item. And so I would need to detail and provide to the board all of the history on this. So I think I think COPRAC should look at whether or not it makes sense to invest the time in this. And I don't know what the right answer is. I don't know what the solution is. But that was kind of, I think, my biggest issue regarding making changes to this rule. And if COPRAC does move forward with it, I think we are going to have, very specific reasoning and rationale to support whatever the COPRAC puts forth.
Okay, thank you. We're going to go to Eleanor, then Carrie, then Aaron. So Eleanor.
Actually, I meant to bring my hand down. Rachel covered one of the points I wanted to make.
Okay, thank you. Carrie.
Yeah, I just wanted to mention that since 2018, I think that there has been important shifts both in California law, especially when it comes to like non-competes. And then there's also been shifts in other jurisdictions that at one point were more restrictive and now have moved, and they didn't even move to a middle ground. They moved full on ABA screen is sufficient. So I just wanted to flag that there is a trend toward free markets and employee mobility. And I think that necessarily maybe wasn't captured almost a decade ago when this was initially looked at. And so maybe that is just, I don't know, a different circumstance to consider.
Meaning the trend is toward more workable screens.
Yeah.
Okay, Aaron.
I personally think the purpose of this rule and all the rules of professional conduct are to protect clients and the integrity of the profession. We want clients to be able to be fully candid and provide really highly sensitive information to their lawyers and their legal team so that they can get the best advice possible. So while I'm not at all disagreeing that, there has been a movement, with respect to vis-a-vis lawyers to allow more mobility and all of those other considerations, our primary purpose of having this rule is to protect clients and the client's confidence that they can be fully candid and fully forthcoming with their legal team. I personally would find it very uncomfortable, someone that did thousands of hours of document review of confidential information now can be, supposedly screened by just changing sides, in the firm. So I personally think California has already struck a balance with respect to, when there are narrowly tailored screens. I personally do a lot of work with respect to motions to disqualify. It really is, it's focused on whether or not there was access in that, substantial former work to information that might be valuable in the current a situation where you're going to be adverse to your former client. So I personally think this is a wrong, it's not the proper way to go. I don't think it's a direction. There's a reason why California didn't make this change earlier, and it's not that we weren't ready for it. It's that we, as a, I think just like we heard in the public comment, and we'll get there a little bit later, there's a reason why California is different on certain things, because I think the emphasis on protecting clients, and by protecting clients, we're also protecting the profession. That's the truth, because then clients can have a lot more faith in whatever they're doing in the administration of justice as a whole. So I don't think this is the right approach.
Carrie.
So I just want to, and I completely hear what Erin is saying, and I agree in many respects, but if we were to look at a hypothetical, say that there is a litigation pending in Chicago, and the firm hires 2 new associates, one who is licensed in Texas and one who is licensed in California. And those 2 associates worked together on this matter on the other side. Say that they worked at the same firm on this litigation on the other side, and the litigation is pending in Chicago. So now the firm is looking at the jurisdictions where the litigation is pending, because the tribunal under 8.5 might apply their own rules, or they might apply the rules of the jurisdictions that have over the 2 associates. But so that means now that under the Illinois rule and under the Texas rule, the Texas associate gets the job, but under the Illinois rule, the California associate gets the job, but under the California rule, it doesn't. 2 associates with the exact same exposure to confidential information with completely disparate outcomes. And so I guess that's the point I want to highlight, is just like, this just seems to be an unfair restriction on California licensees in a way that is not doing anything to further client protection, because someone with the exact same information who just happens to be licensed somewhere else gets a pass. So that's my only point, is just like, in practice, this doesn't protect clients the way that we necessarily think that it would.
I mean, I think philosophically, the argument, you make a really good point, Carrie. I think the argument would be like, we do let paralegals and other people who have significant exposure and maybe doing substantive work move, and it really hinges on the effectiveness of the screen. Like, you must have an effective screen. If you can't have an effective screen, this wouldn't apply. And that might be an area where the committee or the working group could do a little bit more work and thinking. But I think the question is, does the effective screen address the integrity issues and the concerns about protecting client information if the exposure involves somebody who's not involved in high-level strategic decisions or control and high responsibility for the matter? That's really the issue.
Yeah, I had a follow-up on that. I'd like to just make 2 points. One, on the effectiveness of the screen in the context of in-house counsel, where a person is hired for a company with regard to specific technology that they probably have experience with as a lawyer, AI or self-driving cars or whatever the technology may be. How effective is the screen in that context, if at all? Are they even going to be able to be screened in an in-house department where they were hired for their knowledge about the technology of the competitor? Yes, but just the technology itself and the alternatives. The second one is Carrie's point from earlier was partly that these limitations being different are in tension to some extent with the policy disfavoring restrictions on competition and favoring lawyer mobility. So to the extent that there is a client protection question, and this rule makes it slightly less stringent, it would be in favor of those other 2 public policies that California has espoused support for.
on your second point, I think that's absolutely right. I think Carrie's point was that those policies become stronger since this rule was originally adopted. So maybe it's time to consider a rebalancing.
Okay.
The effective screening point, Dan, I do think there's quite a bit of law on that and about the size of the department, whether or not you can actually have screening. Are people working closely together? Are they in different offices, different subject matter? I think there's law that we could turn to resolve that issue.
Yeah.
And Rachel can let me know, but I think a lot of the case law relies on the rules. So I think the change in the rules would address some of those concerns, not all the concerns. I mean, if the intent of the board and the court is not to change this and to continue with the balance that was stricken previously, obviously that's their prerogative. But I do think the case law is probably not the biggest hurdle.
I tend to agree, partly because the cases in other areas that are slightly different than the rules are decided on what is more objectively obvious to a court. Like, did you have access to confidential information? Versus holding a mini trial on all these factors, which you would have to do to try to assess, okay, were you making decisions in directing it in some fashion? Versus something that I can see based on the record of just you had access to confidential information. And to the analogy is like in disqualification cases, that's frequently what courts cite because it's the first and most obvious factor they can assess. Aaron.
Well, one thing I would say with that kind of a mini trial, so you're asking the client in order to establish this, substantial relationship. It's not, you're basically making the client that wants to knock the firm out disclose potential confidential information to try to establish the fact that this lawyer has much more control than they're now claiming, because obviously they're claiming not to, in order to try to maintain the relationship, the current representation. So
that's why it doesn't happen, because the courts look to something objective that doesn't require them to have a mini trial on a motion to disqualification, which is itself a mini trial of the thing they're trying to do, right? And so I think the cases are skewed toward the confidentiality factor, because once you get that, you don't have to ask any other questions typically. And it's obvious on the record typically. Allison.
If we don't move forward with the committee working on a rule change, which I'm not sure if that's where we are or not landing, I do think listening to all of this, that in the comments, it's important for people to know that there was a change in 2018 and that we shifted, and that might need to be clarified in the comments at least, so that a judge or whoever else at least knows where to start looking and doesn't have to do such a deep dive every time they're reading this rule.
Yeah, that's a good thought. I agree with. Can I go back to the working group and just ask what specifically led you to a rule change, instead of just describing these things and saying if you substantially participated, then you might have an issue. But so what led you to a rule change to resolve this rather than the opinion where we started?
I think maybe we can all give our opinion. We were working on the actual opinion, and then we came up with this problem. So I think, Dan, you kind of asked this question, was like, and let's just do a hypothetical. So an attorney working for Waymo on their IP team wants to go work at Uber in, their IP team on self-driving cars. Not a good idea, right? Screening's not going to help. Like in either version of the rule, it's not going to help, right? You cannot hire somebody to basically work on a competitor's matter for a number of reasons, including the fact that, just the confidential information, the strategy, et cetera, but also on the IP side, there's something called Rule 56 information, there's trade secret information, et cetera. That's not what we're covering here, right? We think that might already be addressed. What we're covering here is something that we believe sets California apart, but also has some unintended consequences. So the idea is we could opine on an opinion, we could go to a comment, and just frankly, I'm usually not the one that's in favor of making rule changes. So I was sufficiently convinced by the rest of our group that a rule change like this to make things clear and align things with what practice in most jurisdictions looks like to some extent. And again, that helps lawyers, especially helps younger junior lawyers that may have been exposed to information to be able to lateral into other positions and grow their career. That's, I think, in my opinion, how we got to a rule change versus anything else.
I'll just say, I think the change is substantial enough, and there's probably case law interpreting the current language that, to me, if we're going to go this direction, I view it as substantive enough to require a rule change rather than just a different interpretation of the existing standard, which is all that a change to the comment would give in my view. And I think that wouldn't be very compelling given the case law.
Yeah, so just to come back to the opinion part of it, I think one of the original concepts of the opinion was to sort of lay out issues that in-house lawyers should be thinking about when they make a move. It's not necessarily going to be in the very obvious case of tech companies that are the exact same, very highly specialized technology, whatever that may be. But that is how technology companies are organized to some extent. And if you are an in-house lawyer, that might be your thing, and a place where you can get a job, and you may not have thought about it. It presents really very difficult procedural issues for analyzing the conflict, because if they come to the door and tell you all the things they know, well, the cat's out of the bag already. So you have to assess first whether they know something that is relevant to something that you know. And it's not always going to be as obvious as you work at the company across the street that does exactly the same thing. But this is how tech companies are organized, and they're hiring people for this reason, because they know a thing about AI or whatever. So one of my thoughts was that the opinion was, or at least the origin of it, if I remember correctly, was the idea that we're signaling to in-house lawyers that they have to treat this differently. First of all, treat it at all, as many of the in-house lawyers don't think about it necessarily. But second, treat it differently and have both the candidate and the company have to have a different process in mind, so that they don't come through the door and say, yeah, I worked on this at an AI company, and then in the interview, you're basically already violating it, right? Does that strike anybody as what we started with or useful? And I know it's not to say that the rule change wouldn't be helpful, but it might be in addition to something else in the opinion that might be useful. Raquel.
Yeah, I recall the in-house counsel opinions, of which there was at least two, being more how you said it was bringing to attention that in-house counsels do have rules to follow, and that they're not working solely at the behest of their employer, which is typically how it's done, how their mindset. So that's how I see, and then I've seen it evolved. I haven't heard, I'm thinking to what you said, Rachel, we would need to have a compelling rationale for a rule change. I haven't heard one in this dialogue we're having. So I do relate to that is the standard for which to determine whether we have one. I mean, I think there's people who have given out different examples of things, but that's I don't think it's going to be compelling. So I will say that. And then in terms of the title of this opinion, with this idea of a lateral transition, I think it simply means between companies, but the use of lateral typically means something at the same level. And I don't think it's that this is the meaning of that. In other words, I may move to somewhere else at a higher level. And by that, having that title, it doesn't really, so that title, I think it's movement between organizations, which lateral transition doesn't describe that accurately. So I'll just say that. That's it.
Cassidy.
Yeah, so I just wanted to chime in on the origin of this issue, I guess. because I was there at the beginning.
Yeah.
And for the newer members, yes, this was all part of one in-house opinion about what in-house lawyers should be thinking about in terms of conflicts. I think it basically was just conflicts, but on the one point, we separated it out into the two opinions. So I don't have, I'm ambivalent about the rule change. But I do think we should maintain the focus on in-house lawyers specifically because of what Raquel is saying, that there needs to be an opinion focused on particular issues relating to in-house lawyers and how the rules apply to them. And that was kind of the fundamental focus of the original opinion and now two opinions. So I'm in favor of an opinion on this issue. How it plays out with a rule change. If they go on, simultaneous tracks, I don't know what that looks like, but I do think by just proposing a rule change that applies across the board, we're diluting the intent of giving guidance to in-house lawyers.
My thought would be that the opinion wouldn't necessarily go away because the guidance would still be helpful for in-house lawyers. Emil.
So I think maybe the idea would be we could decide on this issue first and then address the opinion, because the opinion would essentially hinge partially on this, because this issue is of great import in the analysis of, and maybe I can speak to the point about lateral. But I think that's a term used when lawyers move from one firm to another. I think you're right. It does generally connote that it's at the same level, but it also happens that like an associate becomes a partner at a new firm, or somebody moves from one in-house group to another. So I definitely think that the idea of a lateral opinion is great, but the threshold issue is if we could provide clarity through a rule, then great. And if the group decides we don't want to provide this clarity, or there's not enough support at our COPRAC level, then we would just go back to the opinion. But if we can go through this, we would go through the rule change and then move on to the opinion.
Cassidy.
Just real quick, when you guys were talking about the rule change, I mean, and I don't know if this makes sense at all, but did you consider addressing, differentiating the in-house experience, or is that too complicated or not appropriate for putting something, mentioning in-house lawyers in the comment, how the rule might be applied differently in that context?
I mean, I don't think it's in the comment, but it is in this document, in the explanation. It does mention that, I think, in the first few paragraphs, and then in explaining the the problem just right immediately above this. So it's not in the comment, but it's in, let's call it the little rule history that we have right above this, or the rationale for the change.
And that's for the board. Like that would go that would be part of the justification for the rule change. But of course it wouldn't be published unless it's published as part of like the history of the comments.
I believe that it does get published, because I think when we come back to present something, I believe that justification memo, because it was in the other rules, right? Like, wasn't there an explanation, kind of almost like legislative history? Rachel, could you refresh our recollection on that?
Yes, that's correct.
Okay.
Yeah, I mean, that's if somebody wants to go and do a deep dive into,
Sure.
it would be there publicly. Okay, that's just.
All right, let me suggest a process that we might want to do, since this red line, blue line, whatever it's going to be, came out this morning for the group, is that we look at this, and I'm happy to also look at Texas, New York, and we should also compare the model rules. But I do want to keep us focused on two things. One is, should we consider a rule change if so, in what way, so everybody move up the learning curve on this issue? And two, maybe that's a secondary thing, or this is a secondary thing, is what would the opinion and the guidance look like before, during, or after a potential rule change. So I think that we should study this more and pick it up in September because it just came out this morning. But I think we should keep both the opinion and the potential rule change on our list. Because we did have a suite of these in-house opinions, as Raquel said, that came out to provide sort of fundamental guidance on something that seemed to be skewed, which was doesn't seem like the rules apply to what we're doing here. Obviously, many people do have nuanced views of that, and there's a lot of things that in-house lawyers might do where the rules don't neatly apply. But we're trying to signal in this multiple different levels that they're still there and they're still licensed people. So, okay. Any other comments on this? And does anybody object to putting this to September and studying it more and looking at these issues more closely?
So then the committee, all of us would get more familiar in the working group. Is there anything they're going to be doing in the interim based on how you're asking us to proceed, or are they relying on us to do some work only?
Good question. What do you propose, working group, that you'll do to elucidate us in September?
We'll continue to eat the elephant.
At the risk of offending our California centric audience, we might look at Texas and New York and see what they've done.
I mean, I can tell you what they did, but
that's hearsay. I'll look at it myself. Okay. I think so let me just ask what the status of the opinion is and where it ended up. I think it sounds like it was possibly held in favor of a rule change. Okay.
That is correct. I think as of May, we had decided to consider doing a rule change. And then, since May, we've been focusing on this.
Okay. What I propose is that the working group focus on the comments and considerations that Rachel brought up related to the high hurdles that might exist for modifying the rule in light of the legislative history of the rule, and that the rest of us will focus on this red line, and we'll come back in September and say we do or don't think that a rule change is a good idea, pursue it, and we would then also pursue a suitable opinion based on that. Eleanor.
I don't know if there's an appetite for this, but one approach might be to try to prepare, a brief memo talking about the policy conflicts that we see and what the opinion would be aiming to address in those, and see if could that be presented to the board, to see if there's an appetite for the committee to focus on this, to see if a better balance can be struck, whether it's the one that's been proposed or something different. Before investing the time. Rachel, I don't know if that's something that the committee, I think COPRAC's done that in the past to try to get guidance.
Yeah.
I can look into it. I'm not aware of anything off the top of my head, but staff can research that in the interim and get back to you for the September meeting.
Okay. And if you could even get back in advance, that would be of COPRAC September meeting, that would be helpful.
Well, I think it'll be a helpful exercise for the working group to create that brief. Why wouldn't, you're close to it, so make the argument for next month.
Yeah, I think we've talked about it an awful lot. I think we could bake it into the document. That might be more productive if we were going to move forward. But if there's if there's an appetite for a policy analysis, we can do that.
It's not a full-blown 50-page thing. It's like a couple of paragraphs of why we're doing this, basically.
Oh, sure. Yeah, that's easy. Yeah.
Could I also add that the working group also have whatever their opinion is at whatever state be circulated, so that we can refresh ourselves with what that was against this rule for comparison perspectives?
Yeah.
And can the working group please send staff a complete red lines, and then we can email that out to all of COPRAC to review for the next meeting?
Sounds good.
And then if we could just get the lead, Emil, your lead, right?
That's correct. I'm lead. Vikita is the editor, and Carrie is the scheduler. And then Eleanor is also in the group.
Thank
Participant.
you.
Yeah.
Okay, thank you for that deep dive. That is interesting. There's definitely, whenever the trends change, and honestly now it seems like just yesterday, but 2018 was a long time ago. Okay. Anything else on this? Item 4.5 is 26-001. When lawyers make mistakes. Cassidy.
Okay, so the working group, this opinion is almost done. The working group did meet and go over some substantive revisions and the draft. Sorry, here. Can you hear me?
Some weird echo though.
There's an echo.
Okay.
Somebody needs to unmute. Yeah.
Okay. So it is almost done. One of the issues that, so just to kind of set the table here, this is an opinion that covers when lawyers make mistakes and what a lawyer, how to recognize the mistake, which we draw heavily on the ABA opinion as to how to recognize a mistake has been made. But then what happens next, which is there a conflict, a material limitation conflict, and how to deal with that. And then another issue is, charging for the work associated with the mistake, either the mistake itself, the work that was the mistake, and then correcting the mistake. And so one of the questions that we were sort of noodling on was, is charging for that type of work unconscionable under Rule 1.5? And it sounds, like the knee-jerk reaction is, well, of course it is. And so we debated it, and Nick really had some good, Nick and Aaron both had some really good comments about that. And one of the things that we're kind of stuck on is that unconscionability is measured at the outset of the engagement. So it's a timing issue. So when the mistake happens and you're charging for it, it's not necessarily unconscionable under the way the 1.5 is applied. So we need more research on that. There might be other, like an 8.4 violation for, like overreaching basically, for charging for that sort of thing. So we want to flesh that out more. But we expect that the first draft of the opinion will be ready for review at the next meeting.
It strikes me that you should potentially assess whether deciding to charge a client for a mistake that you made is a sign of cognitive impairment. Have you looked at that angle? Sounds
right,
like the
exactly.
dumbest thing I've ever heard in my life.
Yeah, I mean, it's just there. You should not do that. But is it an unreasonable fee, or is it actually an ethical violation? And we kind of land on yes, of course, but like, what does that analysis look like? Nick, did I butcher that, or is there more to add?
I like to take a very methodical approach in addressing that specific issue about the non-appropriate billing for mistakes. What are the theories? There is a duty of competence that's imposed upon lawyers under the rules of professional conduct. But a violation of those rules is the basis for discipline by the state bar. It doesn't turn into a direct civil action by an aggrieved client against the attorney. So what are the vehicles that you could use to address or redress improper billing for mistakes? Number one, do we look at material mistakes versus just garden variety everyday mistakes? I drove 4 hours to a deposition because I miscalendared it. There is no dispute that I spent 3 hours doing it, but can any attorney worth their salt actually bill a client those 3 hours for that mistake. Guess what? I see those in fee disputes every day, that a client says, it doesn't matter what I didn't do right. I spent the time. Under the contract, I'm entitled to this fee. What are the legal theories that say that is the wrong conclusion, the wrong analysis? Can't use rules of professional conduct because that's not an appropriate vehicle. Is it professional negligence? Professional negligence, if you look at the theory of damages that are a consequence of professional negligence, may not actually include the errant fees. So remember, we have a tort contract law dichotomy in California that has to be explored. Is it a breach of contract? Believe it or not, we have 175 years of case law. I cannot find a case that says when a lawyer makes a mistake, he's breaching his contract with his client. I've found cases that says, we impute upon the client, or pardon me, upon the lawyer, a duty of good faith and fair dealing, but does the analogy go to competence? Is there an element of competence when you enter an agreement with a client that a breach of would then constitute a breach of contract for which there be recompense for direct damages, incidental and consequential damages in California law? So I've spoken to a number of presiding arbitrators, past and present. I've spoken to some of my colleagues from the committee on mandatory fee arbitration, and I'm trying to put together some semblance of an approach to basically say, by the way, I'm going to put it together, and as we discussed in our group, we may then have to hand it off to staff to see if they can do additional research to verify, in fact, that there aren't any cases that actually say what we're trying to say. Because I think it does impute or constitute a breach of contract. You make a mistake, you shouldn't bill for the mistake, and you shouldn't bill for correcting the mistake. In most instances, whether that mistake is material or otherwise. Because if you think about it, we go back to contract law, the first week, benefit of the bargain. Does the client get anything from the benefit of you making a mistake or having to correct it? And so it doesn't have to do with formation. It doesn't have to do with consideration. It just basically, what are the expectations, the objective expectations of a client? And the objective expectation of the client is that the lawyer is not going to screw up and make a mistake. And if he does, or she does, or they do, then they're not going to bill them for that mistake or correcting it. So I'm looking at breach of contract, whether or not we can extend it to some sort of tort liability. And, under Business and Professions Code 6200, I think it's 6203, in a fee dispute before mandatory fee arbitration, of which there are many in California now, we can look at professional malpractice only to the extent that it affects the value of the disputed fees, not to award affirmative damages to the aggrieved client. So we're trying to find a pathway to address this specific issue. Fees for mistakes and correcting mistakes. Oh, and unconscionability, just so that I put it out there. Unconscionability under Rule 1.5 is determined at the time the contract is entered into. It was the same under 4200 or 2400 before its predecessor. And the case law is unambiguous as to what constitutes an unconscionable fee under the rules of professional conduct, as opposed to unconscionable conduct, which is rather amorphous and is predicated on the facts of and circumstances of individual cases. But Cassidy, I've come to the conclusion that unconscionable fee really has no place. I mean, there might be in a footnote, but the reality is that if it's an unconscionable fee, it's not just as to the mistake. it infects the entire contract and the entire fee, and it could be disgorged in its entirety, even absent the mistake. So I'm not sure that's the appropriate approach to this issue.
Well, yeah, I mean, in the debate that we've had, and I agree with that, but the question is okay, is it unethical to charge the client for fees associated with the mistake? And you're basically saying no, it should be addressed in under tort and contract law, but it's not a discipline matter.
No,
so that's kind of, go ahead.
I'm sorry, I may have misspoke. It is unethical to do so, but it does not provide an aggrieved client a direct civil action against the attorney for redress. A rule of professional conduct is only the basis for discipline by the state bar. I haven't found anything relating to it providing a direct civil claim against an attorney.
But what's the rule violation then?
One of competence.
Oh, competence. Okay.
I feel like I could make a demur proof claim under 17200 for that, but that's my own particular bias.
But so I mean, so this is the debate, that we had, and that because the focus of the opinion has to be on, is it if it's unethical, what's the rule, what's the analysis, on this issue. So we're trying to nail that down.
And I really like the disciplined approach. A couple of things come to mind. I expect, Nick, and correct me if I'm wrong, but when you surveyed people who actually decide this, they didn't permit lawyers to bill for mistakes in particular instances, on the most part. I mean, I'd be surprised if they did. But then you're asking the right question, which is why exactly did you not? And one thing that comes to mind when we look at a lot of client fee agreements is sometimes the wording is we will competently provide legal services or we will charge you reasonable fees. So the standards are incorporated into the actual contract itself. That does happen.
That's absolutely true. But if you even look at the sample fee agreements that were put together that are available on the State's Bar website, competent representation is not one of the key terms.
No, I know. We often take it out ourselves. We're like, let's not go crazy here. Okay.
And, Cassidy just brought something up that maybe you'd like to consider. Because I was going to consider later on in new business that I was going to propose that we perhaps consider the propriety of a new arbitration advisory dealing with not how to determine reasonable fees, but the basis of fees in a fee dispute here in California, which is an oft misunderstood concept. And Cassidy brings up a good point. Do we want this discussion regarding the appropriateness of fees for mistake to be in this opinion, or do we want it in a separate arbitration advisory?
Well, I think it'd be both because the arbitration
yeah.
advisory would address, should you be able to charge for those fees? Does the client get awarded those fees and why? And the opinion is there an ethical violation for charging for these fees? I mean, those are the, because I don't think our opinion should go into civil disputes, or fee disputes.
Except that is the logic, as Nick points out. Like it's not directly recoverable as a violation in and of itself. You have to have some other thing, which is the contract, right?
Right.
Okay.
Right.
That certainly sounds like you're on the right path.
Or off on a tangent.
No, they're not tangents, but they might be not resolvable as they often are. That's where we live.
Per usual. That seems to be my MO. Okay, so we've got let's just confirm I'm the lead drafter. Emil, you were the schedule, or no, who is the scheduler?
Yes, I think it is me.
Oh, sorry, Emil, and I forgot I didn't forget. I just now remember.
Yeah.
You're the scheduler, and I don't know if we have an editor. I can't remember. Was it Nick or Aaron. But
Sounds like Nick.
No, it wasn't Nick. It was originally Aaron, but I don't mind. Either way, I'm going to have that portion regarding
right.
damages. I'll have that by the 21st.
Okay, so let's Nick, you'll be the editor. And then we'll figure out our meeting. So we have another block, we have another meeting on Friday as the default. Is that where we're going with this? Yeah. Okay, we're good.
Yes, that staff will give you the least conflicted window on Friday of next week, and it can be altered if you have particular conflicts, but there will be a meeting in a week of some sort to do the next thing.
Great.
Okay. Thank you very much. We are just at 11:55, so I suggest we take a lunch break and come back at 1 p.m. Sound good?
Sounds great.
No objection? So moved. Thank you.
We are recording, Chair.
Hello and welcome back to the Committee on Professional Responsibility and Conduct. We're back on our agenda. It's number 5, item 4.6. This is a draft ethics alert, lawyer as an expert witness, from me. And I circulated this just this week, so I don't know, we haven't met as a working group. So I think today's task would be just to get initial thoughts on a couple of different things. One, the substance of this. Second, also, whether this type of ethics alert and content has a positive purpose, could be helpful to folks. You'll see in the alert draft, if you haven't yet read it, that some of what we did when we downgraded it to an alert was just sort of identify issues rather than resolve them, because some of them couldn't be resolved. And specifically, the question of whether serving as an expert witness is 100% of the time the practice of law or representing a party, and there are some authority for that, but not California authority, and it's not clear that it would be true in every instance for something that an expert does. So the first question is just on the substance and more generally on an ethics alerts, because we haven't had a ton of these, but what does everybody think about these in terms of their actual utility for practitioners? And then if anybody has any comments, I think I'd like to hear from the working group next week about it, and then we would tee it up for approval at the next meeting and get it out. Eleanor. Sorry, go.
Sure. I was just going to say, I think the topic is a good one. I think this is something that attorneys and law firms struggle with a bit. So giving some guidance here on the factors to consider, I think is helpful to lawyers.
Yeah, I mean, is it guidance? That's why it took longer than expected, because every time I tried to make an actual affirmative statement, I was like, well, we really can't say too much in an alert. So, Emil, what were you thinking?
So I like the brevity of alerts. I think it's a great solution to kind of what people now have a very short attention span. But
I've already stopped listening to what you're saying right now.
But my biggest comment is, yes, it's reminding us of things that we need to consider, which if that's the goal, then yes. But it's not saying that if you previously represented somebody that you can or cannot be an expert. And it's not saying that if you previously were an expert, you can or cannot represent somebody. So are we trying to, should we say that? Or is that just beyond the terms of this?
Yeah, and that's why it got downgraded from an opinion to an alert, because this has been around for a long time. This has been out to public comment multiple times, and there's been a lot of split opinion, as there often is on these controversial items. The question is, how can we say without California authority that being an expert is not the practice of law? And the question is also, how could we say without California authority that it is? And so we reached this crossroads where we just couldn't, I think, fairly resolve it without kind of legislating or adjudicating this issue. And that's something that would have to be. And I think the working group's consensus was that there are some types of expert engagements that are very, very close to the practice of law, like a non-testifying expert who's analyzing issues and giving, analysis. It's hard to say exactly whether that would or wouldn't be on the right side of the line. A testifying expert who's, going to be removed from the client relationship and is giving ostensibly objective testimony, that's different. But there are instances where people are brought in with no intention ever to testify, and they don't have the same remove from the clients, which could make this, representation of a client question a lot closer.
No, I get that. But would it be then helpful to talk about the trust account issue as it relates to experts? Is this a good place to?
That's another alert, actually, I think that Aaron is doing.
Okay.
The experts are on alert on this.
Yeah.
I believe.
So would it be helpful then to combine these two? Kind of like what should, experts?
Maybe.
Yeah.
That's a good point. Yeah, that's a good question. Things for experts to think about. I don't hate that idea. Well, Erin isn't here right now. When we get to hers, I think we can talk about that. Okay, I think the alerts can be useful. It's a little bit of odd nomenclature because it's not really an alert of something new, but it doesn't have to be necessarily. At a minimum, it's just identifying the issues because I don't think experts in some instances really would necessarily think about conflicts or how to resolve it. Many would, but it was a very contentious opinion that just didn't. It's not uncommon that we get to a certain question in opinions where we're not really going to get an answer unless we're legislating or adjudicating, which we don't really do. And so highlighting the issues is the guidance and the value that we can provide. Okay, so procedurally, I would connect with the working group on this next week in our assigned slot, and then we can tweak this. And when we get to Aaron's expert thing, I think we'll talk about maybe we could combine them into a Uber alert. Any other questions on this? Comments? There's not really any format for an alert, so you're kind of free to do whatever it is you want to do.
Can we get the editor and scheduler rules, please?
Eleanor.
I guess I do have one question. Was the working group able to come up with a scenario where acting as an expert would be the practice of law?
I'm going on memory, but I think the closest scenario was one I described where like you're not going to be a testifying expert. You're retained as an expert, consulting expert, and you actually, through your actions or the way you do it, since you're not testifying, are really giving the client advice in the context of an objective opinion, if that makes sense. I mean, consulting experts don't disclose. Yeah, there's a lot more liberties you can take as a consulting expert than you would ever take as a testifying expert, because that's all going to come out. And so what is really the difference between a consulting expert giving an opinion about the merits of your case and a legal opinion? So where we ended up.
That's interesting. Okay.
Just as an example, Nick.
Yeah. So that was one of the things that I was trying to grapple with. The concept of as to as to a current client.
I would never ever do that. I don't know that anybody.
I understand.
Yeah.
None of us would ever do this.
Right.
The problem is that by reading this, it seems to indicate that I might be able to do this. So,
Well, right.
and I just want to walk through this sort of conceptually. As to a current client hires me to represent them in a fee dispute as the attorney, as the advocate. Simultaneously, the other side wants to hire me as a consultant to look at anything untoward has been done. I can't reconcile the two things.
Yeah, maybe we should clarify. I don't think it contemplates the same person doing both of those things. I think it's more about your firm, a current client of your firm.
Okay, even if it's my firm and
Yeah.
we're a multinational where we can put up, it's funny, and I don't want to put my foot in my mouth. When I learned these concepts, we used to refer to as Chinese walls. We didn't talk about screens or things. We used a really charged term.
Right.
So let's say that I'm in California and I'm hired to represent client in the fee dispute. However, a partner in my New York office that can be completely shielded from my advocacy is hired by the defense to provide consulting work. Basically, their determination of what was done in this matter as to this client. I cannot reconcile those two things. No matter how many barriers I put in between me as the advocate in California and my partner or an associate, doesn't have to be that close of a nexus or connection, but somebody from the same firm in another jurisdiction advising my adversary on the exact same task.
Correct. You just walked the journey that we've been walking for some time. And let me just tell you what the logic of it is in the language of the rule. And if anybody has a bright idea, now is certainly well past the time to bring it up. But the idea is that in the first instance, the consulting expert or the expert, period, is not representing a client because expert work doesn't involve representing a client, which is therefore not a conflict under the strict language of either of these rules, and not the practice of law under the ABA concept in the first place. So you have two different levels. One, either the rules don't even apply because it's like a dry cleaner situation or not the practice of law, which expert testimony, at least there's authority from the ABA that it isn't. Or then, the other element is you're not representing a client as an expert. You're not actually in kind of a client relationship with the party, theoretically.
Daniel, I understand all of that.
Mhm.
I have trouble reconciling it with my understanding. I've never seen, and I apologized, maybe I have to do some outside research regarding what constitutes conduct that can reasonably be included under the rules of professional conduct and those that cannot.
So yeah, that's only half the story. So we all reached the point where you are now, where you're like, how could this be, right? I think, where you're saying, how could that scenario that you just described not be a violation of something?
Right. And typically I would consider it to be a violation of that rubric that we use in California, fiduciary duty.
So that's exactly where we went. And we drafted a version of this that had section 3 flipped 180 degrees to the point where it said it would be impossible to meet your fiduciary duty to your client, even if it weren't a violation of these technical rules, and even if expert work is not the practice of law. And the public comment then flipped and was also as antagonistic, which basically said there's no real authority in California for any of those propositions. I mean, there's fiduciary duties, yes, but that people said was sort of extrapolating it out. And half the committee, I think, wasn't really totally convinced by Section 3 the way it came together. I'm happy to share that with you because it did. We went on that journey that you just went through exactly over, maybe 12 months. And because I was one of the people with Brandon who said this can't be. And so I went looking for what else. And of course, we stopped at a fiduciary duty and I wrote it up and said it can't be done. And then the other half of the population of public comments sort of disliked that.
I feel odd. As you were talking, I was going back through some of my stuff, and I apologize, but I think this is the first time I've ever encountered this ethics alert. So I'm wondering if it was in one of my prior meetings. I've only been to a few that it was discussed, and I completely zoned out.
No. It was this the first time this has ever been circulated. It previously was an opinion that evolved.
Okay. All right.
Yeah, it was 20-00 1 and multiple draft opinions that went out for public comment. And the first one said, not a problem. Scenario 3, current client, your firm represents, and you're an expert in for, against that matter, against that client, related or unrelated or whatever, it doesn't get implicated. So that was hated. And people brought up logical problems with the concept that there is no California authority for the ABA proposition, which is expert work is not the practice of law. And not really a great deal of authority about what representing a person means in the context of these roles or representing a client. So, and I never liked that outcome. It didn't make any sense to me. So with others on the working group, we then wrote up the fiduciary duty analysis saying, even if it didn't violate, the rules, you couldn't do it and comply with your fiduciary duties to the client. Neither party could permit this. And that was also quite controversial.
Right. And so that is my point. And thank you for the clarification. I'm also then struck by the realization that a firm can provide services to a current client and concurrently providing non-legal representation to the adverse party and not be required under 1.7 to disclose that to the current client.
It's mentioned in here for that reason, because, you might have to, but kind of this is the alertness of it is that, there's a reference to 1.7C, and before we eliminate it, it's there. And at some point, that's kind of all the alert does is just say, look, there's this, there's that, there's the other. That's why I wondered whether there's tremendous value, because I don't want this to imply that it's okay. You just have to think about these considerations, because I don't think it would be. You know what I mean? And I would never do it. And I think anybody who did it should have their head examined. But that's not the world. People do things for money, and people come up with lots of reasons why it's okay. And so I don't want this to condone that, but I'm not also, the alert is language is so neutral. It's like, think about these issues and, what do you have to do?
So I think we've all been in practicing lawyers long enough, with the exception of the non-lawyer members, that we see a lot of crazy things in practice. I actually had a client once hire the opposing attorney to represent him in the same case I was suing him in. And he didn't understand that he couldn't do that. And that he had to then substitute me out. And I had to actually ask to be I had to make a motion to withdraw. And the judge looked and he goes, no, you have now a duty to protect this guy because he doesn't understand. And so how do you do these things? My concern, and this is sort of a long way to this point, I hear what you're saying, but it's odd. This may be legally a coherent argument, but is it one that we should make? I mean, you do a good
Well,
job
that's the
to.
thing. I don't mean to imply, and that's why I think this needs to be, worked, because this first draft shouldn't leave anybody with the impression that this is okay, just need to check a few boxes. I actually don't think it ever would be okay because of the fiduciary duty analysis myself, which I wrote, and everybody, again, it was highly controversial. Like some of these opinions, half the world hates it, and half the world loves it. And then if you alter it, it switches just like that. I don't even like the first argument, frankly, this is what Aaron and I and others in the working group talked about, which is because of the scenario I described for Eleanor's question, it doesn't really ring true to me that you could say as a blanket rule, being an expert is never the practice of law. But there are a lot of non-lawyers who are experts. And just because lawyers do it doesn't mean it's the practice of law. But we're also not going to say that it is in every instance, because then the non-lawyers are committing UPL, which they're not, obviously. Eleanor.
You could also have lawyers committing UPL if they're practicing as experts in jurisdictions in which they're not licensed. But
that's true. Yeah, which happens a lot.
Is what you're saying really that you can't cloak legal services in an expert contract to escape, your fiduciary duties? Or are you saying that being an expert can be the practice of law? I guess I see those two a little differently.
I think both.
Okay.
I mean, my opinion is that in some instances, like the scenario that I described with the consulting expert, it could be very close to the practice of law, and you'd be hard pressed to argue that it ain't. Because what you're doing and what the actual counsel for that party is doing is virtually identical. But to your second question, yes, you can't use this to get out of the fiduciary duty because that still exists. And I think a court looking at this is what we tried to convey in the revision with the fiduciary duty section was a court looking to this would just shake their head and say, what were you thinking? Right? But we've talked about this quite a bit. We went through the journey that Nick just illustrated. It was a perfect illustration of the intellectual exercise. And Nick, I'll share with you the revised opinion where I'll give you both, where it started and then the revision, and both of them were equally controversial to the extent that we downgraded it to an alert and just said, let's just identify some of these issues. Because we can't really define out of whole cloth, or I don't think we should, that being an expert is not the practice of law. It's not quite that clear to me in every single instance that that's true. Okay, well, I can see that this persists in being both illogical and unwelcome. It's been on this journey for a long time, but I will share these opinions with you, Nick, and I'd be very happy to sort of get feedback from anyone because I don't want this alert to leave the opinion, to make the implication that these things are okay as long as you think about something or whatever. But this is where the challenge of an alert comes from, because if it were solely up to me, we would just do number 2 version of the opinion and say fiduciary duties prohibit this in this scenario. There wasn't, I don't even think, majority approval for that on the committee.
When was the last time we took that query with the committee? Is it enough new people that maybe we could do that?
It's a great question because sometimes when personnel changes, people are a
Right.
little more friendly to different ideas. I think it was probably in the beginning of this term.
I also just want to flag Vikita's not here
I was
today,
going to
but
say, yeah.
Yeah.
Vikita had a really great perspective to bring to this as someone who is a non-attorney and a expert in employment law matters. So without her perspective here, I think we are missing that as well.
That's right.
Yeah, the last time I remember talking about it, it was with Vakita. So that's my last time.
Because so many non-lawyers serve as experts in
Right.
many different ways, obviously, many different topics require expert testimony that is not from lawyers. Those folks would tend to say, if you have anything that suggests that expert testimony is not the practice of law, I don't want to hear it, basically, for obvious reasons. I mean, meaning it could be, even as a consulting expert. And then you get into the situation where we often find ourselves where you're like, well, it isn't if a non-lawyer does it, but it is if a lawyer does it.
Right.
Which is another weird corner that we've experienced many times. Okay, I'd like to give the working group's views, and I'll share those opinions with you, Nick, because you're running perilously close to being appointed to this working group with all these comments you're making. You sound like a great candidate for
You
it.
can have my spot.
You can take my spot. Just a little too slow. Sorry, Carrie, you said it first. Okay, let's move on, but I appreciate your comments, Nick, and thank you for digging into it. You may not find what you're looking for in this journey, but I want to give you the things we've done. Any other comments on this?
Can we get the rest of the roles, please? Editor and scheduler.
Yeah. Let's say that Carrie is the editor. Yeah, Carrie? Yeah, okay. And I will say that Erin would be the scheduler. Just tentatively, we'll just make her a scheduler.
Okay, thank you.
Okay. Number 6, 4.7, another ethics alert. This is the cryptocurrency, and this is Eleanor. Similar path, much different topic.
Very similar path. It's been around a while. In its current form, it's a hotliner. The working group has discussed it. I think there's more to discuss. We've been actually talking to staff, but I'll give the committee an overview and then solicit comments that we can consider as we look to finalize this. The issue addressed by the hotliner is pretty narrow. It's just whether a lawyer can accept crypto as payment for legal fees and costs. And the current draft, unlike earlier ones, lands on a qualified yes. The qualification turns entirely on timing. So we're concluding that a lawyer can take crypto for fees that are already earned and costs already incurred, but not for unearned fees and costs, because there's no way to hold it that would satisfy trust accounting or property safekeeping rules. So it's really about, can you comply with the rules and holding something in trust for the client, and holding crypto in trust for the client. And when you look at that, there's two issues. There's, if it's funds, you've got the trust accounting rules, and if it's property, you've got the safekeeping rules, and there's some overlap there, but just generally, that's how we're looking at it. And the draft doesn't take a position on whether crypto is property or funds. In earlier drafts, we took the position it was property, and that was based on the IRS interpretation, and we thought well supported. But in discussions with staff, we understood that as part of the research into, whether lawyers could use Venmo and tools like Zelle and things like that in accepting money, one of the conclusions was that they received funds in an account that was not qualified, that would be commingling by definition, and that would apply to receiving crypto in a wallet that is not qualified. So that implied, at least to the working group, or at least to me, that the view was that crypto was funds. And so the current draft doesn't take a position on it, but says, look, it has characteristics of both. If it's funds, it's commingling if you take it into a wallet. And if it's property, you're not able to safekeep it in the way that the rules and the cases would anticipate safekeeping. And we lay out some of the reasons why, which are similar to what's appeared in earlier opinions. So I can talk through any of those issues, or, I can tell you the one that I think we're looking for the most feedback on, if anybody has views, is whether or not we need to decide the issue of property versus funds. And if anyone has a view that, I think one of the things I'm struggling with is, if it's property, is it really fair to say you can't safekeep it if it's going transiently through a wallet and then immediately into a trust account? And you've got a client who's accepted that risk. But I think, Rachel, I understood from your comments that it was clear that taking crypto into a wallet was commingling, and that would be prohibited. So on that basis, we've written the alert the way we have.
So it's something different than getting a chicken in for your legal services and then selling the chicken and depositing the cash. It would be going into the IOLTA account as crypto?
No, it would be going into a digital wallet, converting kind of simultaneously, and then hitting the IOLTA account. To my knowledge, there are no IOLTA accounts that can hold crypto. No qualified accounts that can hold crypto. And as long as that remains the case, and we evaluate under that model, it cannot comply, and it would be commingling the moment it hits the account. So that eliminates taking crypto, converting it, and putting it into a trust account. Then you've got can you safekeep it otherwise? And I think you have a similar issue. The account's not qualified. If you consider, but I don't know. For me, it kind of goes back to the property versus funds thing. Carrie, you want to chime in?
I mean, maybe I'm just so ignorant on but I liked what Dan just said about it being a chicken, because crypto is, I know it's not a security, and I know it's not a currency. It's a commodity, digital commodity. And so is it like holding just property? I mean, that's not a settled question?
We viewed it as largely settled by the IRS position in an earlier draft, but I think if you view it as property, you would analyze it. It may not be as clear as this, so I just want to throw that out there, but I think you mostly analyze it under the safekeeping analysis, as opposed to that it has to go into the trust account, right? And there are challenges, I think, in meeting that and what traditional safekeeping is. But I think you could arguably meet them, or leave room that it's possible to meet them, and that the client's comfortable with those. Those are risks the client might accept.
Yeah.
Well,
and so, go ahead.
Sorry. Well, I guess so. The IRS views it as property.
Yes.
But the way the IRS says that you're taxed on it is actually very much.
I should say generally views it as property.
Yeah. The way you're taxed on it is just the way you would be if you had a stock or a bond, right? So if a client pays you with stock, right, that's not a private company and all that, like theoretically, you could get a paper share copy, although, those are held with clearing companies. But what would you do in that case? Right? You could theoretically keep that property separate from your own. So I think it is settled from the first Nebraska opinion to all the other opinions that it is property, and it's not currency, it's not cash that you can deposit into an account. So if the question is, whether or not you tell the client to transition it into cash, or you do something else, shouldn't we kind of try to make that determination then on what we believe is appropriate for California attorneys, because it is untitled? Like, it could be helpful to say this is what, without guidance, this is, what, without like cases to cite, this is how it's interpreted. Like, this is what the IRS says, this is what the other opinions are. This would be a practical way to do it or to not do it.
So just on the issue of whether it's property versus funds, I think we can make a very strong argument that it is property. I don't know that you need to make the argument it's not a security in order to do that, because I think there is some crypto that has been designated as security. But I think that we can take that position. My question, I guess, for staff, and this is something we're still working through, is does the determination that we understood to have occurred that it's commingling if it goes into a personal wallet apply if it's property? Because it could be in a personal safe, and if it's property, and that wouldn't be commingling. Right. So that's where we got hung up on this designation issue, like whether we can call it property with certainty.
And the trick in part is that the wallet seems a lot like an account.
Right.
It's not.
It's got features of both.
Right.
Yeah.
Okay.
Hey, Nima, maybe you could chime in. We have maybe it's an opportunity to hear from you. We didn't able to hear at our working group.
Yeah, no, of course. I tend to think that I tend to agree with Eleanor here on this, the scope here. But so like I guess my question is like with crypto, because it is so different, like if we're not taking a sort of a material rules-based view here, like what's the downside in getting the hotliner out rather than because I feel like this opinion has been on the table since I joined the committee like 2 years ago.
Yeah, and before that, long before that.
Yeah, it's like and like now crypto is like we're moving into like year 10 of crypto and
right.
It's the second wave now. We've already had two so I don't know, I just feel like we beat it to death. So I whatever gets us to the finish line, I think would be ideal.
At some point, one of the reasons that it was paused or delayed was the regulations around crypto were moving so quickly that it was either going to be solved or clarified in some way that would help resolve this issue, like how to treat it in the regulation context. And then the question for folks who are monitoring this is that are we on the verge right now of the complete deregulation of crypto? It sounds
we're not on the
like
verge of deregulation. We're very much in deregulation. I mean, the administration's crypto guidance basically undoes a significant amount of the SEC and CFTC's regulatory work over the past decade, and there's still state enforcement, spotty state enforcement. I think California is a state that does still look at these cases a little bit differently, but as a practical matter, I mean, these things are prolific and people are, I mean, there's public exchanges now. I mean, a lot of people use them. So, I think at least as it relates to like common coins, like, it would be good to have some guidance for attorneys, particularly attorneys who work in the space. Like, you have a lot of crypto clients, like you may want to participate in whatever their project is.
If you represent a wallet company, or if like your firm does, and you're privy to like material non-public information, and based off of that information, you want to take your tokens out of the wallet, can you do that? It's not trading. It's not trading on MNPI, but
if it's not a security, then yeah, you can. I'd have to look at the specific argument, but I mean, look, fraud laws still apply. So if you're I think that would be a risky thing to do if you're privy to information and other representations are being made to other holders of a token. But I think for the kind of tokens that we're talking about here, these are like mainstream tokens. These are not like, we're talking like Bitcoin, like Ethereum, stuff that is like, pretty I won't say fungible, but like it's
Don't say mainstream because none of us feel like that's mainstream, but that's okay.
Well, yeah, in
your world it may be.
Fungible is a good characterization though, and that gets it away from the property analysis.
Well, that's right. Yeah.
Can you bank run a wallet?
No. So a wallet is just an individual, like you would have your individual wallet, like your online wallet. Wallets by definition can't be bank run. Now, exchanges and vaults that hold crypto coins and like particularly like loan pools, there have been a number of high profile like public hacks in the last few years of that, but that doesn't theoretically doesn't directly impact a user's wallet. And the idea is that, I mean, I've seen situations where like, people will like get into your wallet by some like, social engineering trick, but getting your wallets are really hard to hack because they're specific to individuals and the very complicated code and so forth that an individual uses to protect their wallet.
And luckily for me, I had a polymarket bet on whether Carrie would ask that question, so I just cashed it.
There you go. That's a bigger problem.
So Nima,
But
are
you're not
you
gambling, so
Not gambling, right?
Not
are you
gambling.
coming down on the side of its property or its I'm going to use currency, that's not the word, but the other funds, funds.
I'm coming down on the side that at least the fungible stuff is funds, because if it can be switched into money as easy as Bitcoin can, I don't see how it's materially different.
It does seem like the fungibility for me is the difference because it's not the very same chicken that your client gave you. It's chickens or a chicken of whatever sort.
So if you look at it that way, though, then the struggle I was having wrestling with this was then it looks more like funds. If you take it into the wallet, staff's view is that is commingling. That is a violation. It can only be accepted into a qualified account. So at that point, really the only answer is for the client to convert it and transfer it as fiat currency.
But then it's not crypto. It's not even
That's right. That's right. So can you take it into a wallet?
If it's for an invoice for work you've already done, that's where you started, right? That
Absolutely.
makes sense.
That's where she started.
I think everyone's in agreement on that one. I don't think that's super controversial. This is really about custodial funds, right? It's purely an issue of being a custodian, and the standards are different if it's funds versus property. I'm not sure you can meet them for either, although in reality, I mean, I think Nima makes a really good point. It's like near simultaneous conversion, so, and it's less volatile than it used to be if you're talking about these large coins. So if you've got near simultaneous conversion going into an account, a client's accepting the risk, it's all informed, it doesn't concern me all that much, but I think we have a view that we can't take crypto into personal account without commingling.
Well, I think, yeah, and I think that's right. I think it's just the question that I have is like, if it comes into, I mean, I could do this with my own like Bank of America account, for example. Like I have it connected to my crypto wallet. And if I transfer crypto to the Bank of America account, it immediately converts to whatever the price differential is, and then it puts the money in the account. So it's, you can do that fairly simply.
But then when it's hitting your account, it's US dollars or some fiat currency.
Well, yeah, I mean, like I use this example like my account, but like if you like, I don't know.
Sorry, when it's hitting the lawyer's account, trust account, it would be
dollars, correct?
Well, now it sounds a bit more like foreign exchange funds, which would be treated exactly the same way, right?
Well, that's what I'm saying. Like, what if like okay, so here's the hypothetical. I have a wallet. Let's just use a mainline wallet. I have a wallet on Coinbase. Client wants to pay me 3 Bitcoin in connection with my representation. He doesn't want to go through the process himself of like converting it to cash. He's like, here, I'm just going to type in your wallet address and send you the 3 Bitcoin. Bitcoin lands in my account, and I immediately transfer it to my bank account, and then it converts like simultaneously. Like, why is not?
Because you just commingled in your wallet.
And exactly, staff has opined on. We understand that there's a view at the bar that is commingling, even if it's near simultaneous. And I can appreciate that, but that seems like it's a conclusion based on the trust accounting rules. And
it's not really conceptually different than if it just went to your checking account and you transferred it over very quickly or immediately.
But you have to commingle funds. And so if you're not,
well, there's other stuff in the wallet.
This is just another chicken in your.
Hold on. What if you don't have other stuff in your wallet? Like what if you can have?
It's not a trust account.
Yeah. Well, okay, but like if you don't have a wallet, like you can have a number of wallets. Like, so I could say like, here's my wallet for whatever, like for situations where I accept crypto. And that only goes to that. And so there's no commingling, and it immediately goes through the wallet to the bank account.
I think the conclusion was commingling and misappropriation. And I think it applies if we're talking about funds, and maybe I'm mistaken here. Maybe there's more overlap in these concepts than I'm appreciating, but that's why, I don't know, Rachel, if you have anything to say on this one, but when you come back with the analysis on the account saying we can't accept crypto in a personal wallet, and there is no qualified wallet, so that would be taking crypto, would be, commingling or misappropriation. I got a little bit confused about whether or not we can take the position it's property, because I think if it's property, you could make an argument that taking it into a wallet where there is no other funds and it's going to have an instantaneous transfer is perhaps acceptable and secure and
Emil and then Allison.
So under the old version of Rule 1.15 before 2018, there was kind of a safe harbor that you could promptly take money and put it into a trust account. So you could, ZBA, whatever, that money and then put it into a trust account. Now, you're not supposed to take any, advanced fees unless they're earned upon receipt into an operating account. Right. So I think when it comes to considering it to be funds or currency, there's not really much to be done unless there's a safe harbor added to 1.15. However, if you look at it under the property analysis, 1.15D says a lawyer shall identify and label securities and properties of a client or other person promptly upon receipt and place them into a safe deposit box or other place of safekeeping as soon as practicable. So it doesn't say that you have to keep only one client in there. So you can have a safe deposit full of a bunch of stuff. You can have a other place of safekeeping. So, I mean, if a client came to me and said, "Can I, accept cryptocurrency?" I would say, no, it's not a great idea to accept it in advance. That's personally what I would say advice-wise. But is there a defendable position based upon the way the rule is written that you could, create a separate wallet or something? Yeah, I mean, I would definitely keep it separate than your own. But I think there's a defendable position there, and it depends. Is the committee willing to opine on that?
That is the position that we took in the earlier draft of the opinion, was that you could do it, it would be very difficult and challenging. I mean, some of the challenges include, if it's maintained in a wallet, it would be I think what we said is you've got to immediately transfer it into a trust account because that's where you can maintain it. And a wallet, you perhaps can't in today's, and maybe things have changed, but when we looked at it then, it was like, well, you've got these passwords, you've got to share the password, you've got, there's too much risk perhaps to safekeep it in the way that is intended under the rules, like safety deposit box. But I think instantaneous transfer is pretty compelling.
More to a practical point, which has been what Eleanor also has been saying many times, is that the State Bar staff guidance is this is not how it would be treated. And so that's more relevant probably than any other thing we can think of.
Right. Well, that's why I kind of wanted to get more information from, I mean, this has been a helpful conversation, but I think we do need to get a little bit more guidance from staff on whether or not it's fruitful to continue trying to determine whether we can take a position confidently that it's property and whether or not that would change staff's opinion that accepting it in a personal wallet is per se misappropriation, commingling.
Allison.
Okay, so again, maybe I'm wrong on this, but if it was property, even if it was right, and you took it, you put it in your wallet, and then you transferred it to your trust fund, you're converting it to a US currency, right? So even though it's instantaneous, if I were to press a pause button and slow it down, a zillion times, it would be in the wallet. Now it's transferred into cash, then it goes to my account. That's the commingling. Yeah. So I think even under the property analysis, you still have a commingling problem.
Well, I'm not sure if that's right, because I think that what Nima described is that it wouldn't be transferred to currency until it went to the bank.
Interesting.
Yeah, I think the question is it can you appropriately hold property that way?
Right.
Right.
So the wallet's holding the property, and then you try to transfer it to your bank, and in the transfer it becomes currency and hits the bank as currency. But okay, well, it's a very interesting question because this is the thing that looks like it could be different, but I go back to the concept of guidance for practitioners would be centered on how it might be treated by the State Bar.
Yeah.
And so I do think it's worth going back and checking in on that.
We are doing that. I think it's really a custody question and, the characterization of the nature of the instrument. And so hopefully we'll get some more guidance on that, which will inform how we.
The next alert will be whether 3 Bitcoin is an unconscionable fee for NEMA service. We have no idea.
Eleanor, can I get Eleanor quickly? And I apologize. From a practical reality, I do have colleagues that have adopted Emil's perspective that not only with crypto, but also with gold, diamonds, they treat it as property.
Mm-hmm.
Some practitioners deal, and we're talking about fees not earned, costs not yet incurred. So they will hold either the crypto or the gold or some other property, either in kind or as collateral. That's the term that they use. but they don't do anything with it other than possess it and safeguard it until the client has been advised and notified that they now owe X number of dollars in fees and costs. And I thought that that subsequent conversion of that property, whatever it is, whether it's a Bitcoin or an ounce of gold or whatever it is, then is no longer subject to the formality of having to be segregated in a non-operating account. And it can be converted into US funds for deposit into an operating account without having the issue of dealing with commingling under the state bar prohibitions. I mean, that's what
that is my understanding, but we are, which is why the conclusion that it's commingling or misappropriation suggests to us that it's regarded as funds or maybe a hybrid by the bar, and we need to kind of pin this down.
All right. There are some third-party, practice pointer, practice tip providers that's what they've explained to be a viable alternative if you seek to accept crypto and other property as advance payments for fees or collateral for advance payments for fees and costs.
Mm-hmm.
If the only stumbling block then from listening is the bar's perception of this last stage transaction, isn't it just easier to get their perspective?
I'm not sure it's the last. Well, that's what we're trying to do. Yeah, we are in communication and trying to get the perspective. But I don't know that it's just a last stage transaction because you're holding it, right? It's during the time you have custody, not just when you convert. There's two issues. You could take it and instantaneously convert it. And in reality, and Nima would know better than I think the lawyer probably never even controls the wallet. So that type of instantaneous conversion to me seems like a foreign transfer, and it seems much more, acceptable, and easy to allocate the risk and say, well, it'll just be what it is when it hits my account, even though it may be coming through an exchange that I control, so to speak. But then there's the other issue. If they give it to you and you're holding it, that holding would be an issue as we understand the bar's current position.
As you understand what, ma'am?
The bar's current position. So not just the conversion of it, but the holding is the issue.
Understood.
And that's because advanced fees have to be held in trust. Unless it's a flat fee, which then can be deposited in an operating account with a waiver. But
yeah, and we haven't really addressed flat fees head on. I think we covered that in a footnote, but agree.
Well, and the flat fee would make it really difficult because then if all of a sudden the price skyrockets, then your flat fee could become unconscionable. And
I think we went with earned versus unearned and just left it at that. So flat fees wouldn't qualify.
And one really important distinction here is that the agreement underlying this deposit of crypto or something else is denominated typically in US funds. So, we're going to charge you X number of dollars per hour. We're going to charge you this flat fee for this task. So, what the attorney is taking in possession of is not this dollar, is something else. And that's why I think that distinction that Emil made is what's being used practically, I think, every day in California. So what I think, I know sometimes I just beat a point to death and I apologize. If really the only stumbling block is the bar's position, I think the bar should be put to the task. You can do that with the IRS. You can just ask for a ref proc or, a letter of intent or something like that. It should be posed to them and say, hey, how do we deal with this? And they, at some point, they've got to clarify their position, because the reality is the membership attorneys are doing it anyway. and they would like to do it correctly once proper guidance is given.
Yeah, fair. I mean, we are in the process of that. I think we're working with the bar and going back and forth right now to get the view. Rachel, I think, has been very helpful in sharing views and reviewing the draft. And I think we're planning to get together to discuss it further, and hopefully we'll have some more clarity on whether the bar, in fact, has a strong position. We've understood it correctly. So,
Raquel.
Two things. One, Eleanor had asked Rachel to chime in, which I want to, before we close, allow Rachel to chime in. The second thing, if I heard Nick correctly on his scenario of how attorneys are using crypto now, Nick said something different than I think our alert is advocating. Ours is for services already rendered, so you already have a definitive fee, if you will. I thought I heard you, Nick, say it could be for services yet to be rendered. Did I hear you say that in your scenario?
That was my point. Yes, Rachel.
Yeah. So this,
But you raised it in a slightly different way, which was they're holding it not as a fee deposit,
but as property,
as
yeah.
collateral,
Right.
for future use.
Right. So, but if I'm understanding, and I'm on that committee, the alert is only dealing, we said that's not part of this conversation. Am I correct, Eleanor, in understanding what we are alerting on? You're on mute.
thank you. The current position in the alert is that an attorney can accept crypto as payment for earned fees and incurred costs, but not unearned fees and unincurred costs, not future fees and costs. So because it can't be held in trust in compliance with the rules.
Right. Okay. So
Or can't be safe kept, held in trust / or safe kept, depending on the analysis.
So I don't know, does that change anything you said, Nick, in terms of advice to the working group?
The lawyers are not following that ethics advice.
Right.
And that's not what they're being instructed by experts in the field. If in fact our bar is adamant that there is a professional prohibition against doing that, they have to be very straightforward, because their silence is creating what I presume to be multiple violations every day by multiple members.
Well, it's a good point. When the working group met, we discussed this, and in particular, the fact that if there is a clear position, and we think that the bar would take the position it's commingling or misappropriation, that maybe this then should become an opinion and not an alert. It was an alert because we didn't seem to have it didn't seem to be announcing anything that was significant. It seemed to be giving guidance as to how to interpret the rules. But if we are taking this position, I think we might want to turn it into an alert, which wouldn't take much additional work. But we need to dig into this and reach a conclusion. Nick, if you've got, you've referred a few times to expert guidance, to practitioners. If you've got any materials you could share with us, it'd be interesting for the working group to see those.
I guess I should disclose it now. I have quite a number of varied colleagues in all aspects of practice. And I learned when I reach out to them on behalf of being a co-prac member, where I may utilize some of their information and other stuff. I was trying to get some people to do public comments on some of our stuff, because they are, I would consider them to be the most learned of our colleagues. They've been around even longer than me. This is the first time that I'm probably one of the oldest people on a committee. And the people I deal with have been around, 10, 15 years longer than me. The only problem is that they still work, and they are expert witnesses, and they're adamant about not making public comments on anything because it may affect their professional tasks going forward. And I respect that. I mean, Eleanor, I will reach out and ask for permission. I have a tendency of, I would have to disclose, hey, by the way, I think what you're doing is wrong according to the bar, but would you mind talking to this working group at COPRAC regarding this point?
I wasn't suggesting that, to be clear. I understood you to be saying that there was published material on this point. If that's not the case, then I don't expect any. That's all I was asking for. Sorry.
Oh, no, you know what? There may be actually something that's written like a practical guidelines that I can maybe pass on to you that I've read.
That'd be great.
And I will look for that.
Thank you.
All right, stay tuned for the continuation of this very interesting topic.
Rachel, are you gonna add something or no?
Yeah, I just wanted to clarify that the bar does not have a position on whether or not crypto is property versus currency. So that is not the issue. I think the issue is I want to make sure that we are, whatever conclusions we come to in the ethics alert, we make sure that we involve CTAP and regulation just to make sure that we are not coming out with anything that may interfere with the CTAP rules and processes. So yeah, as far as I'm aware, the bar does not have a position on that. And Nick, in regards to your comment about public comment, people can absolutely comment anonymously. They can provide public comment live on Zoom anonymously. They don't have to give their name. They can also submit written public comments on specific items for the agenda that are up for public comment using the form, and they do not have to put their name.
That's a great deposition question for an expert. Have you ever submitted an anonymous public comment to the State Bar?
And thanks for clarifying, Rachel. We did understand the bar not to be taking a position on whether it was funds or property, but to be taking a position that it was commingling and misappropriation if it was received in a wallet. And I think our question is whether or not that implies it's funds. But
now I understand the confusion in our emails after this conversation. So I get it, and yeah, we can follow up, and I can have CTAP help as well.
Thank you.
Oh, and can we get the roles for this one as well before we move on, please?
Yeah, I think because it became an alert, we did not assign roles after it became an alert. We can do that now if necessary. I didn't realize we needed defined roles for that. So I've got Nima and Raquel on the working group with me. Do you have preferences about your roles?
Happy to be whatever.
I'm getting off, so I would suggest I don't take a role, right?
I think we should give Raquel both roles.
Just let me get it done.
It's going to be issued before you leave, Raquel.
Yeah, I'll take on everything. I'll get it done.
All right, let's make Nima the editor and then Allison the scheduler.
Oh, Alice is on here too. Okay, great.
Sorry about that.
All right.
All right, thank you. That was very interesting. We'll wait to hear more from you next month about that. Let's move to, we're going to pass 7 and 8 because Erin's not yet back. She notified us she would be delayed in returning. Number 9 has been removed. Number 10, 4.11. Rules 8.2 and 8.4. And this is Emil.
Yes. All right. So I took this one over. Oh, my notes. Sorry, my notes just disappeared. And we did get some comments back, and we came back with our own just very small modifications. And those modifications were that we wanted to remove the term false and reckless, since reckless does not basically have the same language from paragraph A. And we believe that that comment created some confusion with the commenters. So would it be helpful if we could bring up the, what went out on the screen, please?
Yes, 1 second.
Thank you. And I think this will be on page 2, which is the red line. Yeah. So just right where it says lawyers who make, and then the previous text said false and reckless statements, just saying lawyers who make statements against judges and judicial officers from the meeting undermine public confidence. We wanted to correspond to what the actual text of the rule says. So we thought that might be a clarification. So this was obviously one of the issues, is that the rule itself takes out or doesn't necessarily talk about false and reckless directly. But I think it, would be helpful to just align these two together.
All right, questions about that proposed change or any other details in this updated version?
And just historically, this obviously came back. It came from the Supreme Court, and I believe that they came back with quite a few changes to what was originally proposed. So that's where we are right here.
Okay. Without any questions about that proposed change or the others, the question from a procedural perspective, is this ready to be sent out for public comment after a motion?
This is ready to be sent to the board for adoption, and to ask that they send it to the California Supreme Court.
Okay, so it just goes to the board, no public comment.
Yes, we finished our public comment period. The change we made was not a substantive change, so we are ready to move it forward.
Okay, we would entertain a motion to send it to the board as revised.
Motion.
Emil and let's say Nima motion, Emil second, Raquel second.
Emil
Very
motion. Emil
Raquel
motion. Raquel second. Okay.
Sorry, Nima motion, Raquel second.
Okay.
Simultaneous.
Oh, no worries. Ali,
Yes, please.
Brown,
Yes.
Joyce, Matt Watkins,
Yes.
Mercado,
Yes.
Migliaccio,
Yes.
Mohebi,
Yes.
Perlman,
Yes.
Point Dexter, Riley,
Yes.
O'Reilly.
Yes.
Thank you. The motion carries.
Great job. Thank you. For number 11 is 4.12. This is discussion of AI and a possible request to circulate updated rules for public comment or approval by the Board of Trustees. Would be one or the other of those. Which one would it be? Depending on what we do, I suppose.
Yeah, well, there might be make it quick here. There's nothing really to do today. We've received the second, I guess, the follow-up round of public comments, which the subcommittee needs to review. We didn't get as many as the first round, which, although I think Rachel said that we got a few sort of right at the deadline. So we're probably gonna have to schedule one or two meetings before the September meeting, and the idea will be to have those addressed before then.
Okay, great. Processing public comments, and you'll meet next week, Friday, or another time of your choosing.
Yeah, I think we're going to have to meet more than once. Yeah.
Okay. Do we have the roles for this one?
I believe so. I believe I'm.
Nima's doing everything.
It's efficient. Okay, Nima is the lead, and the editor is.
I'm that. I guess I'll take that as well.
And staff's been scheduling, so we can continue to do that.
Okay, great. Careful what you set a precedent for, staff.
We were asked specifically for help on AI and AI alone.
Yeah, right. I have a question about the public commenter this morning, who spoke about Miss Morgan, who spoke about sort of the public interface with AI, which I do think when we had the judge on the ethics symposium that she introduced that, which was not something that the AI working group has heretofore been focused on. So I do think it's something that should be considered. But I'm curious what others think about that, if there's any feedback, people who are either on the working group or not on the working group might share your reaction to that side of the perspective.
Carrie.
Before we discuss it, I want to flag that caller this morning, the case that was mentioned is a case that is being handled by my firm. And so if I should sit this
Recuse
part out,
yourself, yeah.
Yeah, let me know if you guys want me to log off and come back on, or if it's not an issue, but I just wanted to disclose it, that's our client.
You don't need to log out, but I think it would be appropriate to recuse yourself and just not engage in the conversation or partake in any vote on that particular subject. But I will just say that I think her point is absolutely well taken. COPRAC only has authority over attorneys and the rules of professional conduct. But I will say that Office of Professional Competence is actually currently working on a video geared towards members of the public, specifically addressing issues surrounding AI, using AI as an, improper, how to have a conversation with your attorney about AI. So the state bar is doing some education work geared towards the public and AI specifically.
The second part of her comment was that there's a split of decisions around the question of when, if a lawyer is involved, when the client's activities in and of themselves are not privileged. And there are a couple close cases that seem to be kind of close to the line where, for example, lawyers had said do something and the client went and did it, or it was around the time right after the lawyer was retained, before or after, but anticipation of it, retaining the lawyer. So partly this is all so new that the courts are obviously adjudicating it as they come up, but it's creating in the short term some anomalies. Meaning, if a lawyer is involved and I upload something to a secure, not training AI platform, it's privileged. If my client does it on their own before they talk to me, or possibly even after they talk to me, it's not. But the question is whether that's correct, whether that should be that way.
I believe, if I'm remembering correctly, I know that this discussion came up in the working groups, and Nima, you can chime in if I'm forgetting something. But I believe we added that topic to our kind of ongoing list of education and potential either opinion or ethics alert once we finalize the rules.
That was my memory, is that we talked about that as some sort of alert afterwards of
Correct.
like, yeah, just being advice for practitioners.
Yeah. Triage.
Part of the difference in the danger is that the AI companies are, I mean, I don't really remember people going to Google and saying, give me the person's search history in like a civil action, basically. But
That's
that
right.
is that seems like it is happening with AI platforms.
Oh, and it's not just happening, it's happening with
Rapidly.
more vigor in every
Right.
case that I'm
Right.
on.
Yeah, well, the case in New York kind of lit the fuse on that.
Yeah.
Okay. Does that address the public comments as you heard them, right, Raquel?
It does. Both mine was less on the what Rachel you said about public education. Mine was more on the latter, attorney. But I think what you're doing for the public is very helpful.
Okay, great.
Before you move on, Dan, I'm just going to flag that some clients of my firm are also mentioned in the discussion. So I will refrain when those topics come up, refrain from participating.
Nick, it just might be you at the end making this decision, just alone.
I abstain.
Even that. All right, we'll move on in that case. I'm sorry, I skipped over number 9. Was that removed from the agenda, or did I get that wrong? 1.7?
That is still on the agenda.
Okay. Let's come back to that because I skipped over it. That's actually something else that was removed. So this is item 4.10 and another topic of a public comment from this morning. This is 1.7C and Carrie.
Thanks, Dan. Okay, so 1.7C, we got a public comment this morning that was from the attorney who asked us not to throw the baby out with the bathwater. But I think we should look at the value of the bathwater. So we've talked about this, I think, the last 2 meetings, but there is a California exceptionalism baked into Rule 1.7 that was adopted in 2018. And as part of the effort to align the rules, the California rules with the ABA model rules, some language was tacked on to subsection C of Rule 1.7 to include that lawyers would need to disclose to their client, even when there is no risk of a material limitation to the representation. They would need to disclose certain relationships that either the lawyer has or that another lawyer in their firm has. And those are enumerated. We don't have the actual language up right now, but one of the things that got added in there was or responsibility to. So it talks about if the lawyer themselves or another lawyer in the firm has a legal, business, financial, professional, or personal relationship or responsibility to. So one proposal, and just to be clear, it's an incoherent in like the academic sense. Lawyers cannot comply with this section without potentially violating their duty of confidentiality that they owe to their clients under 1.6. Because if you have a confidential representation, and what the example that was given was that you represented a petitioner in a potential TRO application that they ended up deciding not to pursue. And then say a year later, that former client of yours ends up being a witness to a hit and run in a matter that that somebody else at your firm is handling. Technically, under this rule, the lawyer would need to disclose that prior confidential relationship because responsibility two can be reasonably read to include a duty of confidentiality. And so it's this incoherent requirement. And then the footnote basically says, but if you can't comply with it, if there is some other obligation that means that you can't make these disclosures under C, well, then you just can't take on the representation. And we think that that is a unreasonable restriction on on lawyers. And then also the responsibility to language seems like it might have just been inadvertently stuck in there anyway, just to make it align with the language in B without necessarily like thinking through what the implication would be under C by including responsibility too. So when we first started talking about this, we were just going to strike the responsibility to language, and then we thought, well, maybe we should look a little bit more generally at this subsection C, given that there are no other jurisdictions that require this, and kind of think about other hypotheticals and the type of information that would need to be disclosed under this section and whether it's actually doing the work that we think it is. And then we also wanted to contrast the type of information, the really like private information that could potentially be disclosed pursuant to 1.7C. And we gave hypotheticals about like seeing your law partner in a doctor's office waiting room when you go there to go have like an expert consultation, and you would need to disclose to your clients that your partner is being treated by that physician. And it could be like a very, I gave the example of, say that the doctor expert specializes in like, erectile dysfunction. That could be like a very embarrassing thing to have to disclose about your law partner. And then, or certainly it would be a very personal thing to disclose. And then we also talked about how there are other things like a lawyer's substance abuse disorder that, if they are in treatment for it and it's managed, there is absolutely zero obligation for a lawyer to disclose their own substance abuse disorders or mental health disorders under Rule 1.4. If there's no risk of it bearing on the representation, you absolutely don't need to disclose it. And so we were thinking about how we protect really personal information that could actually really bear on the representation. And then here, information that we've already deemed to not bear on the representation, we're requiring lawyers to disclose. So that's a lot. So I want to hear what other people think.
Yeah, we've talked about this a couple of times, and I think the concept for today would be whether we want to put out for public comment one of the two versions, which would be the light version would be take out or responsibility to, and strike that phrase. And then the heavier version would be strike C. And to Carrie's point, there is a logical circular journey here when responsibility to includes confidentiality, which you absolutely would have with every former client or current client. and you couldn't do it, so you couldn't ever take on those matters according to the comment plus this language. And then two was the question there is more or less whether any of this really is, some of which is extremely personal information about the lawyer, their partners, families, and so forth, would really make a significant difference to a client. This morning's public comment obviously suggested let the client figure that out once they know. But
and to that point, like, well, then we should also be disclosing to our clients that we are, you know, in a 10-year recovery for a substance abuse disorder, you know, or that we have a mental health disorder that currently, you know, under control and has been under control for 25 years. But, you know, if we're going to just take this position that more information is better, like we should just tell our clients everything, and we should give them our credit scores, and we should tell them if we've ever declared bankruptcy. And like there's like a wealth of information that sure the client could contemplate when they're hiring us, but we're not required to completely give up our personal lives as attorneys.
you have one. You're not doing it right. I was going to say this is conflict adjacent situations, and obviously the rationale would be that a client would like to know, for example, if you are married to opposing counsel or somewhat, something, or your son is suing your client or something like that. And then the more practical question is whether there's an appetite in the bar or in the Supreme Court for less disclosures in the current moment. I've talked and Carrie's talked. I'd like to hear other folks reacting to that and the public comment from this morning, which was, don't get rid of the disclosure. It's not hurting anything. It's more disclosure is always better. But in this case, as Carrie's pointed out, there's some defects in this, and it's the only one like it in the country. And I do wonder whether anybody ever really does it at this level. There are lots of ways where you could logically conclude that it can't be done. Eleanor.
Yeah, I agree with your last comment. I think we have probably many practitioners violating this, maybe not even aware of it, because it's so broad. So I'm in favor of removing it and proposing that. But I think if the committee is not, I think we should give a thought to perhaps other ways to modify it. I think maybe there's another option that we could put on the table versus just the minimal and the robust. If there's a middle ground. But I'm interested in hearing what people think, because I think removing it, I think there's adequate protection in the other rules and in sub B.
Emil.
So what about putting in a comment that says, like a comment to 1.7b that maybe discusses a material limitation may include, and because I think there is an ABA opinion that talks about C2, like, right, that there's an opinion about that, but I think we're focused on maybe C1, and it's that kind of amorphous relationship, and maybe say in certain instances it may be helpful, like just kind of talking about it from a comment, just because what I'm thinking is that by removing it, a lot of the public, the Supreme Court, the board may say, looks like you're changing a requirement. And instead, what maybe we're trying to do is take it out from the black letter and put it into the comments by saying it may still be appropriate, but it's not to the level that it deserves to be its own, section of the rule. Do you think that might be a way to
folding it in as a comment to B is what you're suggesting? Yeah,
exactly.
but retaining the concept. I think that's interesting. Yeah.
But a narrower version of this, because
Right.
we don't want to have the doctor's office thing. We don't want to have those sorts of
The
scenarios.
confidentiality, right?
Yeah.
It may require, I think the ABA, or at least there's another jurisdiction that has a comment to be that describes what would constitute a material limitation, and I think it includes family relationships. I do think that would be a good middle ground, is to expand the concept or clarify it in comments to sub B.
I like that idea. I think so if other people have thoughts, I mean, if that were the course we decided to take, we would come up with the comment. And the strike through of C would then be accompanied by the concept in a more limited way being present in a comment to B.
I think strikes a good balance.
Yeah, because there is some element to the conflict adjacent relationships, like that, yeah, after the fact, the client would be surprised to find this out, right? And undismayed. But it's as drafted, it's really broad and illogical in certain instances and also questionable utility.
We can also bake into that comment that this is like an objective standard. It's not subjective to what the lawyer thinks is a material limitation, but what like a reasonable client would think was a material limitation, and then that could also help clarify it.
If it's a comment to B, you come back to the significant risk concept, right? And so it's tied to that as well, which is part of the problem with C, is that it isn't. Cassidy.
You guys we may have already covered this at the prior meetings, but are we saying that disclosures that may come under this rule or under a comment to the rule is not necessarily a significant development that would fall under Rule 1.4? You know what I mean? Like, or because if it's lower than that standard, then, but I don't know if is that.
I think
what was the outcome of that conversation, or did we have that conversation?
I remember having the conversation, at least in writing with the working group, and I think our view was like between 1.4 and B, you're covering a lot of ground, and C is overkill, and it covers situations where there's absolutely no risk to the representation. And
yeah, I mean, so yeah, go ahead. Sorry.
No, that's the point.
Yeah, so if it doesn't rise to the level of a significant development,
and there's no
I'm
risk.
I'm sorry. Are there
it
situations
doesn't fall within B, right?
Yeah, I mean, so again, there's other rules that cover it. So I like the idea of a comment because it just kind of provides more guidance. But I would also reference 1.4 in the comment to say that that's kind of like the minimum threshold,
right?
That it could be a significant it has to be a significant development, right?
Okay, well,
under 1.4.
Yeah, that would be probably a floor under B. Can we commend the working group to come up with the draft comment? So it would be like strike this and add this, and it would fold C into a comment to B referencing 1.4.
Yeah, is there consensus on that?
And then just to make sure that this, I feel like it keeps getting kicked down the road. If we did do the draft comment and the striking, would the committee be okay? Like, would they be comfortable voting that out? Or are there people who share concerns like from the public comment this morning that even with those changes, they would not be comfortable with this? Because I want to make sure we're hearing from those voices too.
I think Erin might be one of those voices. I believe she's mentioned that in the past. She's not here at the moment, but we'll certainly hear from her when she's back or to the next time. But I would be in favor of that change. Are there folks who would be more on the side of our public comment from this morning who said, don't make less disclosure, that ain't going to help anybody? Okay.
I mean, I think that
Raquel?
the implication, and don't throw the baby out with the bathwater, is that some of it might be bad, some of it might be worth tossing. And our goal with the comment will be to preserve what's not, what's worth preserving, and to highlight that we have other rules that cover this area.
Keeping the baby in, as it were.
Exactly. So hopefully, I think it was Mr. Freifelder who commented, but he'll have an opportunity to comment when we put it out for public comment. I'm sure we got others too.
Yeah. Okay. I don't think we need to take a vote on whether we should have the working group assess whether they can come up with a comment to be.
Okay. Great. No, that I just wanted to make sure, because when we were doing the 7.3, even when we got the language, I felt like there were some dissenters who didn't have or didn't feel comfortable or didn't have an opportunity to raise their concerns. So I just wanted to make sure that we're like, if there are other things that the committee would like us to consider while we're working on this, like I would like to hear your concerns now.
Yeah, I believe there are at least one or two other members who weren't present who might have concerns.
Well, we can outvote them. So no, I'm just kidding.
Right. We don't care that much. No,
if you're not here, this is a very time sensitive objection period.
That's right. You won't be heard to complain, as they say. Yeah, no, I think you can also connect with them individually and say, we think you may have had an objection to this that was similar to the public comment. What do you have to help us, essentially? So
yeah, I hope that the dissenting voices have something more than just more disclosure is better, because like I said, there are so many things that we are not required to disclose that could have more significance on a representation.
And even if you were a dissenter to that concept and objected to it, as our caller did this morning, they might see it differently or approve of a comment that brings the same requirement up into B.
Right. Yeah.
Or a modified version, obviously.
Right.
Yeah. Okay. The working group will start down that path and come back to us next month with something to review. Thank you.
Can we get the editor and scheduler, please, for that working group? Cleat is writing.
I'm gonna say Eleanor is the editor because she's our best writer.
I've been editing.
Because you've been editing. Okay. And then Allison, do you want to be scheduler?
Sure.
Great.
Okay.
Thank you.
Back to number 12, 413 civility discussion, update on status from Eleanor.
This will be a quick one. The working group has met now several times. With staff's help, we've put together a couple different drafts. Just as a reminder, the mandate is to look at ways to codify existing case law on fee reductions. And we've taken a look at quite a few rules where the case law might be referenced, or we might be able to codify the standards. And I think where we're landing now, or the current draft lands, is with a focus on Rule 1.1 competence. We are also working on edits potentially to 3.2 relating to undue delay in litigation and 8.4 misconduct. But the focus is competence, and the reason is that courts already treat uncivil conduct as a marker of lack of skill. And skill is recognized as a lodestar factor, which ties directly to fee issues. And the case law addresses this, and it has the additional benefit of aligning with how the civility toolkit approaches this, which is as a competence issue that lawyers need to be trained on and develop. So we think we've landed on the right focus and the right place to focus the codification, although there may be some others. We're not sure about that yet, but you can be sure you'll see something in competence.
That's an interesting formulation because I think there are many people who use belligerence as a strategy.
Mhm.
And maybe if you can prove that it was on purpose, and that would be a different outcome. But yeah.
So that's the basic update right now. We can talk about it a little bit more if folks are interested. We can talk about the cases, but we didn't find cases dealing with fee reductions that are related to causing undue delay or other issues that have been kicked around. They really had more to do with lack of skill. So that's where we're focusing.
Okay, and the commission is out there and they're doing something?
We have not. I think we've just landed on what we think is the right formulation. We need another meeting or two before we share this again with the commission.
Okay.
We do plan to get their views. We've got, like I said, a meeting scheduled for the 24th, although I'm hopeful that maybe we can meet next Friday as well.
You do have a meeting scheduled next Friday by default, so you must.
Yes. Adam, you're our scheduler. I think you're not available on the 24th. Erin's the editor, and she is available, so we will go forward then. But if you're able to find a time for us before then, I think it would be great, because I think we're actually getting pretty close, and it would be great to get this out to the commission to get their feedback.
Yeah. All right. Thank you, Eleanor. Number 13.
I did have a question just in terms of timing, because I'm updating the work plan as we go along.
Sure.
Is the goal to bring the finalized rule proposal language back to the September meeting to vote it out for public comment at that point?
I don't think that's likely to happen if the working group can't get together before the end of August.
Okay.
If we're able to get like 1 or 2 meetings on calendar in August and get this into the hands of the task force in August, I think September is reasonable.
Okay. So bring back in September.
Yeah, we put out like 5 weeks of invites, so we're having trouble getting the working group together right now.
Got it. Thank you.
You're welcome.
Anything else on that? Okay, thank you. Next up is the discussion regarding and vote regarding requests received for new ethics opinions, rules, or other requests.
Will you pull those up? Perfect. We're going to get those pulled up so that we can go through them. The first one was withdrawn, so we'll start with 14.2 ABA Model Rule 1.14. This was a staff-initiated request. The ABA just recently changed 1.14, and as a result, a lot of states are now looking at their own 1.14 to see if they will be falling in line with the ABA changes. So there was a pretty long PDF that was emailed out to all of the COPRAC members that came from the ABA. And so this is the first time discussing it. So I think at this point we need either someone to be interested to come back and report on it, or if no one is interested, that's fine too.
Rachel, this is a rule that was previously rejected, yes?
Yeah,
Rejected.
It was rejected in 2018 vehemently.
Are you talking about ABA or California?
California.
Okay.
When they were aligning California with with the model rules in 2018, they rejected this pretty strongly.
Based on the heightened confidentiality statutes and rules of California. Although this, yeah.
There's a COPRAC opinion about what to do, and I have used that COPRAC opinion.
Yeah.
It's a good one. But yeah, there's a COPRAC opinion about what to do without Rule 1.14 in California.
And just to be clear, I'm not requesting that COPRAC take this on. I just brought it before the committee because the ABA changed their rule for COPRAC's consideration. We do have a very good COPRAC opinion on this particular issue.
Yeah, and I think we can assess whether the different 1.14 is somehow different. I mean, they reference 1.6. Well, that's something. But because California has its own statutory confidentiality, I think it's tricky to make a rule like this, which is why they didn't take it up last time.
I mean, unless someone on the committee wants to take it up and research and report back, then we can just decline today.
Any takers? I think decline to opine.
Okay, got it.
It's more
Then
exceptionalism.
the next one is 14.3 and attorney signatures. Emil, you were going to present on this one.
I didn't know I was going to present on it today, but happy to happy to present. I guess one of the questions that I wanted to get some clarity on is that the USPTO has been very adamant on a technical requirement for attorney signatures. And I've had discussions, I think, about this in the past. And I did bring it up. I wanted to kind of gauge whether or not there's any interest in talking about let's call it the contours of when an attorney is allowed to sign a document on behalf of a client, or when a paralegal can sign a document on behalf of an attorney. And the example that I'll give you is if we were opposing counsel, or even on the same side in a litigation, and we had to file a stipulation. It's very common in California for, let's say, Nick and I. Nick's going to say, hey, would you agree to this stip? And Nick will say, please, I agree to it. Please let me know if you do. I say, yes, I do. And he puts in my, electronic signature, either, /s/ or /my name/. And then we submit it to the court. No one bats an eye. Unfortunately, the USPTO has been aggressively going after this signature issue, giving people very, disciplinary actions from lengthy suspensions to reprimands and probation. And I think, the California bar in some cases has declined to take reciprocal action. And in other cases, they have taken sometimes even more aggressive action. So I thought it'd be helpful if COPRAC was interested to put forth an opinion, basically opining on whether or not it is appropriate and under what circumstances, if you have the consent, power of attorney, whatever it might be, to sign on behalf of a client, or to allow a paralegal to sign an attorney's name, or again, an attorney signing another attorney's name with their consent. And I apologize, I don't have too much more, because I apologize, I was not prepared.
It's definitely a very common practice, and I think it sounds like going to look for an issue where there might not really be one. What is the concern from those authorities that are prosecuting this as a discipline violation? It's not a Rule 11 question, is it?
Actually, they are saying it's their version of Rule 11, 37 TFR 1118. They also call it lack of diligence and conduct prejudicial to the administration of justice.
But I have your permission. You've agreed. You've told me I can put this on the page.
I know.
Is there a regulatory requirement on signatures that's being violated here, or?
There's also, technically there's a regulatory requirement that says a person must personally enter their signature, but this is being targeted at certain attorneys, and it's just become a widespread problem. There's probably, there's been a couple hundred investigations and probably over 100 disciplinary actions dealing with this now. And those are resulting, I mean, a lot of states are like Texas is barely taking any action. New York generally doesn't take action. California is kind of 50-50 on the reciprocal from these matters.
But meaning disciplining it when somebody does it with permission?
Correct, on a reciprocal basis from the
Right.
USPTO. So the problem is at the USPTO is that people capitulate, and because the USPTO system is like the immediate supervisor of the prosecutor is the one that approves all the decision. There's no state bar court. There's nothing like that. And it's pretty much whatever they submit becomes kind of the force of law. And it would just be helpful to have a state opinion that would explain, whether or not, and, the question is, it's hard to say whether or not that's okay, right? It is very common practice, as you said, Dan.
Well, I mean, I don't think it's that hard personally. I think that the question is more about whether it's authorized. And yes, you could have a bright line rule where only that person's pen moving in on that page could qualify. But so has anybody ever had an assistant file something on ECF?
I mean, I think it's very common to do that, right?
Yeah, right. So that's a Rule 11 binding act.
Yeah.
It seems like the question is more about whether this is an authorized filing with my express permission. In the best case scenario, you get that in writing.
Yep.
Well, if it is, what are we talking about here? That's my opinion.
No, I think that's a fair point. I think there are some opinions that talk about authorization to file on behalf of lawyers, for paralegals, et cetera. And again, I think it is a very, USPTO specific issue right now. But when states are taking reciprocal action based upon that, like California, which is our jurisdiction, I think it begs the question, under like the selling factors and reciprocal discipline, if it's not a violation in our jurisdiction, should we care? And so maybe this could bring some clarity to that. Like, hey, this is common practice. This is not, conduct prejudicial. Especially if it's done with authorization, no client is complaining. No one is, hurt. It's kind of like it's a problem in search of a solution. Solution in search of a problem in terms of how they're doing this. I think Eleanor had something to say.
Yeah, I guess I get a little uncomfortable saying that we wouldn't consider it a violation. I'm just poking around on my little friend Google here. So take this with a grain of salt, but it looks like when you said there's a regulation, I just did a search for regulations and pulled up what looks like there is a regulation that specifically says it must be signed and it must be a personal signature applied by that person. And with S signatures, it says the same thing. Like it's got to be applied by that person. So if you've got a reg that requires personally affix it, and there's an implied certification with that by applying the signature, you're certifying that you've done it yourself and it's being personally signed. I think that's different, and I don't think we would want to say that we're comfortable with lawyers violating a regulation and the representation of clients before the USPTO.
Of course, no, I totally get that, and I don't think that this opinion would opine on that, right? The opinion would opine on whether under California law, it's appropriate for a lawyer to authorize their paralegal to sign their name, whether a lawyer is permitted to have another lawyer sign their name on a stipulation, or whether a lawyer can sign a client's name on a document, again, with their permission. So it would be very, very narrow.
And it wouldn't opine on whether or not a violation of these regs was or would it recognize that you may have other regulatory duties to sign personally?
I think obviously we wouldn't be opining on other people's rules, but I think we could always say there might be a court may say in their local rules that you must do that. Like a paralegal cannot submit documents on your behalf. A paralegal can, there may be local rules in a court, for example, that may say that. So I think that is slightly different.
Is California going after, you mentioned that California had differing approaches here. Has California actually gone after anyone in California?
Yes. So
outside of the USPTO context?
I just pulled up a decision actually that the client or the party originally got a reprimand at the USPTO. California gave them a 30-day suspension for this on a reciprocal basis, which I thought was very, very strange. And in other instances, I just saw a client sent me that they got a warning letter when they had gotten a reprimand from the PTO. Again, all signature-based things. So,
But all related to the violation of the rules.
correct. Generally,
And the
violation. Sorry.
And the regulation.
Yeah, violation of 37 CFR 2.193 or 37 CFR 1.4. But ultimately, the way, depending on how strongly you advocate your position, they'll charge you with the violation of 11.101 competence, 11.103 diligence, 11.104 communication, 11.303 candor to the tribunal, and then potentially 11.503 failure to supervise, and 11.804 false statements, 804C, and 11.804D conduct prejudicial to the administration of justice.
This sounds like a nightmare, but it feels like it's outside of our scope to me. But I'm happy to be overruled and continue discussing it. But
It does sound like it's specific to the regulation from the USPTO. And I don't know whether there's a similar interpretation of Rule 11 out there that means to comply with Rule 11, you have to actually move the pen yourself or put in your password for ECF. I don't think so.
Yeah, not that I'm aware of. Yeah.
Okay. The idea, yeah.
I mean,
so
are we right to assume that the California decisions are based on the violation? Yeah, they're based on the violation of these regs.
Of the law, of the
Nothing else.
regulation.
Yeah.
Well, they're actually based upon just what the final order says, which is violation of the rules of professional conduct, right? So that's really what they look at, is they look at what does the final order say. And yeah.
Interesting.
Is the USPTO just trying to make the point that this has to be done in a very certain way, or are they bad cases where people have done it without actual authority?
I wish I knew. I can say that the complaints come from what might be known as the world's largest online retailer, and they have filed complaints mostly against Chinese American attorneys. And if you look at the disciplinary actions, it really just shows that.
Okay. What does the committee think about taking this up with those contours, or should we leave this where it lies?
Why, Eleanor, do you think this falls out of the jurisdiction of the committee?
Well, I mean, I think if somebody wants to do an analysis of, what a potential opinion would say or do a draft, I'm certainly open to discussing it. But what I'm hearing is that there's a finding in the USPTO of a violation of regs. There's a decision by that body that a lawyer has violated the rules, the ethics rules, and then there's a reciprocal decision in California to impose punishment. And I think what we're mostly reacting to are the rules of the other jurisdiction, as opposed to the reciprocal, recognizing that a violation of the rules where you're practicing might be worthy of or warrant reciprocal punishment or discipline, rather. So I guess I'm a little uncomfortable with it on those grounds. I think.
Thank you.
That's my issue.
I think that's right. It would be tricky to, well, we could come up with something that said California doesn't have such a regulation if we determined that every federal and state court's local rules didn't require it, or you'd have exceptions. But this is just a specific, for whatever reason, they've decided this is their thing. If you practice in that court, you have to do it this way. Apparently, you should know that. And it sounds impractical to me, but lots of laws are.
And just to be clear, it is actually not a court. It's like, patent filings, trademark, they're like literally filing a form online in a, click through type thing. But, yeah.
Even worse.
Yeah.
Courts have to make sense. Yeah. So this forum that has some kind of judicatory authority over attorneys is decided this is important to them.
I mean, if we were going to do something, I think what might be helpful is to flag for attorneys that a violation of this rule could result in reciprocal discipline.
That would be an alert. I mean, be aware.
Right.
I think that would be positive that this is happening. And if you're not aware of this obligation, become aware of it.
That'd be interesting. Yeah.
Won't just be a problem there. It'll be a problem in reciprocal jurisdictions. Yeah.
Right.
Rachel, where would this fall in the workflow of the plan? So we might have some alerts that are getting ready to go out the door.
Yeah, so this one would kind of be our first one if the committee moves and votes and takes it up. It would be the first one in the queue for when a new spot opens when something comes off the work plan.
Okay. Let's take it up when that happens. Because I think it might be good to think about it just a little bit more. I think it would be helpful to signal to people who are in California that this could be the subject of reciprocal jurisdiction. But I also get that when we do even an alert, it could imply that we are criticizing this or something along those lines. I don't know, but it could be done artfully. It could be very helpful for people who might not have heard that this is happening or thought, oh, I don't, it's just going to be the USPTO jurisdiction. It won't affect my California license, but it will or may. Okay. Thanks, Emil.
Thank you.
Rachel, back to you.
Yeah, the last one is 14.4. This is a request that we received regarding the duties of lawyers to timely respond to requests for representation. So duties owed to prospective clients. And there was a written request that was emailed out to all of COPRAC, and Karen is getting it up on the screen now. So this is the first time we are seeing this, so we either need to deny it or have someone volunteer to look into it.
I don't think this needs any analysis. It seems like the grievant or the individual is suggesting a rule change to require an attorney to respond back to a potential new client by a date certain. And while it may be good practice, I'm not sure if a rule change or an opinion is really required here.
Yeah, I think the rules as they currently exist would cover reasonable amounts of time.
Or do you have a duty to respond to every inquiry? I mean,
no,
especially now with AI and stuff that just gets slopped
or that
into
might be
our
spam. Yeah.
Yeah.
There are some inquiries that we receive that appear to be trying to steal my identity.
Yeah, I would steer very clear of fashioning a rule to do that imposes a duty to respond to unsolicited. Well, you shouldn't be soliciting anyway, but
improperly soliciting. Yeah. Anybody else have thoughts or want to pick this up and look into it in more detail? Hearing no interest, we'll decline to opine.
Staff will draft the letter. Thank you.
Thank you. That takes us to number 14, item 415. This is the work plan. And Rachel updates us in real time, moment to moment.
I was derelict in my duties today. I had to frantically catch up this afternoon. Karen's going to get it pulled up in the screen, but I have highlighted the ones that we did not yet talk about. So there are only a few that need to be updated.
Great.
I wonder if you could go to page 4, conversion clauses. So the first one is 20-0005 conversion clauses. If we could just get an update on what we're expecting for September.
Cassidy, I think you and I need to touch base on that one. We haven't put a date on the calendar to talk about it, but I think I need to kind of make sure we're on the same page and then we can move it forward. There may be a research project pending with staff or never made its way to staff, but we are probably close enough to report the progress or perhaps present a draft in September.
Okay. And can we get the editor and scheduler, please?
Our rules have shifted around a bit here, so I'm not entirely sure. I mean, Cassidy took the lead on it for a while, but I think I've been designated as lead recently. So Cassidy, do you want to be editor? And then
Yeah, that's fine. I don't think I was ever the lead, but I will be editor for 1 month.
I don't know who the lead was then.
No, I don't think that I don't either, and I don't think they're on. I think they termed off.
Okay, well, if we can have you as editor for 1 month and I can get the final download, that would be fantastic.
Yeah.
And then I guess we've got 2 others, so whomever wants to be scheduler is fine with me. It's Aaron or Nima.
Neither of them are here at the moment, so I'm going to say it's going to be Aaron.
Okay.
Okay, perfect. Thank you.
This one's been around for a long time in many different versions, and Raquel, right? This has been around.
It's 2-0 in front of it.
Also very controversial in its day.
Yes. This may just die. But I think it's very close. If it's going to go, it'll probably go in close to its current form. I don't think anyone else has an appetite for revisiting it.
What could possibly be said that hasn't yet been said?
I'll just let the entire committee know staff is still working on the DA ethics alert issue. I should be able to bring that back on calendar for September.
Oh yeah, I forgot about that one.
Yeah, that one's been
The
paused
state
for a
bar
while.
deferred that enforcement stuff, right? Is that the current situation?
Yeah, we're still working on it, so I should have an answer by September, and then I think. Oh, and then I just have Erin's left, I believe, are the only 2.
Okay, I don't see her back, so I think we'll have to pass those to next month, and then, or can you reach out directly to her and just have her update?
Yes, can we at least, while we're here, get the roles taken care of while we have the other co-preg members?
Yeah, I'll be the editor for the attorney adjacent.
Okay. And then scheduler for attorney adjacent. The only other person I have on that working group is Vakita.
Yeah, so there should be our scheduler, I think.
Okay. And then the Zell CTA, it's just Aaron and Adam. So I have Aaron as lead. Adam, do you want to be editor and scheduler?
He does, I'm certain of it.
I can't see you guys, so I may just be talking to no one.
He may
Okay.
have left, which is to his own peril, but he'll be both editor.
And that was it on the work plan. Thank you.
Bravo. I would like to move alerts and older opinions up and out. So next Friday, when everybody's meeting, make a plan to move this merchandise. Okay. Number 15, discussion regarding legislative advocacy. Rachel.
Yeah, so I didn't have any further updates. Karen emailed out the Board of Trustees staff memo from the last board meeting with all of the various legislative updates. So I just kept this on the agenda in the event that any of the co-brac members wanted to have a discussion.
Any comments on that legislative advocacy report that Karen circulated? All right, continue on your appointed rounds with that. And the final one, and we'll go straight to Emil for this out of custom new business.
No new business on my end.
No, okay.
What?
Anybody else? New
It's
business?
been 3 months. I guess maybe it hasn't been. I thought 3 months in a row I have had no new business.
Okay. Anybody else have new business for us to consider? Going once, twice? Thank you all very much. We're done.
Thank you.
Thank you.
Thanks, everyone.
Have
Great
a
job.
good weekend.
You too.
Good to see everyone.